notes or put it on D&D. Fill the final.
How much time do you require? They are asking you. Hey, please come. We are calling. Please. Darshan, field code 06 का मेमोरियल की कॉपी दीजिए. How much time do we need to call the judges? How much? Please. We are 20 minutes. This is briefing is almost over. Which side?
Everyone is kindly requested to maintain the decorum. Judges of final rounds will arrive in just 2 minutes. Everyone kindly rise for the judges. The courtroom masters are required to start with the briefing.
May it please the Honorable Bench, the parties are appearing today before the Honorable Supreme Court of India. The Honorable Judges presiding over the forum are Learned Advocate Vishal Sanusia, Learned Advocate Kuldeep Pathak, and Learned Advocate Nitin Singh Bhatt. Team Court IRR 06 is appearing on the behalf of Advocacy, and Team Court IRR 04 is appearing on the behalf of Respondent. The team appellant has reserved 40 minutes for the oral arguments and 5 minutes for rebuttals. And the respondent has reserved 42 minutes for the oral arguments and 3 minutes for rebuttals. Any extension of time can only be granted as per the discretion of the Honorable Bench. The court is now in session. With the permission of the Honorable Bench, Speaker 1 for the appellant requested to begin with the oral arguments.
Am I audible? Greetings to the Honorable Bench. The Council recognizes the prestigious presence of the Honorable Bench. The Council here appears in the matter Arun Mehta and others versus the National Law College Indore and others on the behalf of the petitioner Arun Mehta and others. With the due permission of the Honorable Bench, the Council will now like to state with this statement of jurisdiction. Much obliged. Appellant has approached the Honorable Supreme Court under Article 136, challenging the imperfect judgment of High Court, Madhya Pradesh Bench Indore. The leave has been granted and a substantial question of law and public importance is present in the case, violating the fundamental rights under Article 19(1)(a) and Article 21. The Honorable Supreme Court has an inherent jurisdiction to try, depose, and entertain the present petition by the virtue of Article 136 of the Constitution. With the due permission of the Honorable Bench, the Council will now like to proceed with the statement of facts. The Republic of India is a Soviet socialist secular democratic republic governed by a written constitution, the most cherished function of which is the fundamental rights guaranteed under Part 3 of the Constitution. National Law College Indore, one of the country's most reputed college and a publicly funded educational institute, issued a circular dated 10 July 2025 restricting all the social media platforms within the premises. The circular extends not only to the college Wi-Fi but also to the personal devices of students. R. Mehta, the first-year law student, along with his batchmates, found the restriction violative of the fundamental rights, approached to the College Redressal Committee and then to the Honorable High Court, decision of both of which has validated the validity of circular. Dissatisfied from such, the appellant is now appearing before the Honorable Supreme Court under Article 136. With the due permission of the bench, the Council will now like to proceed with the statement of issues. Much obliged. Statement 1. Whether the SLP filed by the petitioner is maintainable under Article 136 or not is being deemed and is being dealt by the council, and issue 2, whether the circular issued by the college institute is violative of the fundamental rights under Article 91A is also dealt by the council. The later issues, issue 3 and issue 4, will be dealt by my co-counsel. With the due permission of the Honorable Bench, the council will now like to proceed with the arguments. Much obliged. It is most respectfully submitted to the Honorable Supreme Court that the Honorable Supreme Court has an appropriate jurisdiction to entertain the present petition under Article 136, the special leave to grant. As Article 136 ensures an extraordinary discretionary power on Supreme Court against any judgment, decree, order or sentence of any court and tribunal. Also, subject to the case of Jamshedji Hormonji Badia, where it was clearly stated that the framers of the Constitution visualized the Supreme Court as a court having a final and appealing jurisdiction on questions relating to the constitutional validity of law. Has the appellant in the present case has already approached to the College Redressal Committee and then to the Honorable Court, and dissatisfied from the judgment of Honorable High Court, is now appearing in front of the Supreme Court within the appellant jurisdiction granted under Article 136. Therefore, the court having an appropriate jurisdiction to entertain the following petition. Secondly, Your Lordship, the case involves a substantial question of law as a circular issued by the college authorities is violative of the students' fundamental rights guaranteed under Article 91A and Article 21. Supreme Court has also emphasized various times that the right to freedom of speech not only includes the right to express one's views, but also includes the right to get various viewpoints. Subject to the case of A.R. Anatoli vs. R.S. Nanga, where it was observed that even the Supreme Court cannot by its decision deprive a citizen of its fundamental right, and if such deprivation occurs, it is the duty of the court to correct itself. Thus, where a fundamental right is infringed, the Honorable Court jurisdiction is not only justified but necessary. Also, aligned with the principles of Pritam Singh versus the Union, where it was observed that the power ensuring to the court under Article 136 must be used in exceptional cases only. Your Lordship, the present case is one such exceptional case, as it deals with the important question that whether any institution has an authority to infringe the digital freedoms of students in today's digital era. Secondly, Your Lordship, the circular by prohibiting the use of social media, even on personal devices, amounts to a blanket ban on medium of expression, thereby curtailing both the right to express and right to access information. Subjecting to it, the case of Farima Sheehy versus State of Kerala.
Excuse me. आप अभी कौन सा issue address कर रहे हैं?
Issue number 1.
What is the issue number 1?
The maintainability of SLP filed by the petitioner under Article 136.
So you are citing all this regarding maintainability.
Regarding issue 1, yes, because Your Lordship, I was like to link the issue with whether the Supreme Court has a jurisdiction, because the first point was that the Supreme Court has an appropriate jurisdiction, and the second point is whether a substantial question of law is involved in it or not. So I was dealing with that a substantial question of violation of fundamental rights is involved in the case. Secondly, I was dealing with I'm dealing with the circular is inconsistent with the constitutional provision. So now right now I'm explaining that point only. If the Honorable Bench has no further questions, so let's much of it.
If you are addressing the point that is maintainable, you have to stick to the point of maintainability.
Okay. So we like to proceed with the
मैं आप समझे क्या
that you should only stick to the maintainability issue.
क्योंकि फर्स्टली अगर आप ये कोर्ट को कन्विंस करेंगे कि आपकी पिटीशन मेंटेनेबल है, उसके आगे फिर हम अगले पॉइंट्स के ऊपर डिस्कस करेंगे.
Yes.
सिर्फ उसी के ऊपर आप रहिए.
Okay, Lordship, as the bench deems fit. Summing up with the arguments, I would like to come up with my second issue, that whether the circular issued by the college institute is violative of the fundamental right guaranteed under Article 19(1)(a), that is freedom of speech or expression. It is boldly submitted that the circular, by banning all forms of social media within the campus, including personal devices, violates fundamental rights under Article 19(1)(a), as it is well settled that the freedom of speech includes not only the right to express one's view, but also the right to get different information and to have diverse viewpoints. Will the council continue?
Yes.
Much obliged. This dual aspect was also reaffirmed by the court in the cases like Secretary Ministry versus Cricket Association and LIC versus Manubai Disha. The circular by prohibiting students accessing to social media, which is a vital platform in today's digital age, used by mostly the youths and students for educational purposes, for expressing their views, and for getting various viewpoints across the board, is primary and directly infringes both of the aspects of it. As a social media, if infringed in the college, the students cannot have access to the various viewpoints across the world and will not be able to express their viewpoints in a digital age through a digital medium. Especially youths and students are nowadays using a lot of social media platforms like the Instagram, Twitter, Facebook to express views and to get knowledge and educational purpose. They do use certain websites like Manupatra, SSC Online, and various other websites to get knowledge and for educational purposes. Thus, the circular that was issued to ban all such social media platforms and the use of Wi-Fi and personal devices also infringes not only Article 19(1)(a) but also Article 21, but also the freedom of right to privacy under Article 21 of the Constitution. In the today's era, when the world is moving towards digitalization, such circular must be issued with concerning the digital freedoms and rights of the students in the present scenario, and the institute must be acting within all its responsibility to issue such circular and must balance the rights of individuals and institutional autonomy with alternative remedies available to the institution instead of going with such harsh restrictions. With this, the council would like to sum up with its arguments. Summing up with the arguments, if the bench has any further questions, the council will be present to answer that.
Alternate remedy के लिए आपको क्या कहना?
So there are ample of alternative remedies present to the institute to deal with the issue.
What about your alternate remedies?
About whether the about
आप इस ऑर्डर के अगेंस्ट आपने एसएलपी फाइल करी, क्या उस ऑर्डर के लिए कोई अल्टरनेट रेमेडी थी?
Indeed, Your Honor, indeed there are alternative remedies available like Article 32 and the writ review petition under within the High Court. But there are certain issues with both of the alternative remedies available. As the first issue with the first remedy which is available, that is Article 32, is that Article 32 deals with the original jurisdiction that the one should directly approach to the Supreme Court under Article 32 for the violation of fundamental rights. But in the present case, Your Honor,
after order has been passed by the High Court, can approach the Supreme Court under Article 32 after the passing of the High Court order?
No.
Then how can you say that they can directly approach to under Article 32 after passing of the High Court order?
I'm saying that, Your Lordship, that under Article 32, one can approach Supreme Court only.
In your case, you have already
approach. Yes, that is the only point the council is here to explain. That we have.
If the order has been passed by the High Court, then what are the options available to you to challenge this order? How many options are there in order to challenge this order passed by the High Court?
There is only single option that the appellant is being. There is two options actually, a review petition, but there was a slight problem with that alternative. Review petition within the Honorable High Court only, because the High Court
against the order passed by the High Court.
Yes, the prior order was passed by the Honorable High Court of Madhya Pradesh bench Indore. Now we are appearing in this court against that judgment of that Honorable High Court.
Is there any appeal also there?
Yes, sir. Yes. Yeah. We are appearing has an appeal in this only under Article 136, special leave to appeal.
No, there is one more remedies available under the High Court. So it is filing an appeal before the division bench.
Writ appeal. Writ appeal.
Also,
Writ appeal.
after passing in order by the High Court, they are opposed to the
Writ appeal. But
thereafter it can approach to the
Supreme
Court
Court.
under Article 136.
Okay. But your lordship, the council has a little confusion and wants to clear that point with the lordship that there is a slight issue with the alternative of writ appeal, that the Honorable High Court under writ appeal will not reconsider the whole judgment. It will only reconsider the errors on the facts available. It will only reconsider the judgment, not reconsider the actual case again. It was not rehearing the actual case completely, but has a substantial question of law and public importance is involved in this present case. The appellant wants a complete rehearing of the present case. That's why the appellant here approached under Article 136 to the Supreme Court for intervening into the matter to deal with the questions of substantial question of law and public importance.
Judgments are there in this regard. Let the High Court
Sorry, Your Lord.
not hear such appeal.
Which is the point they are.
Judgments are there in this regard that the High Court cannot hear the appeal on this point. Writ appeal on this point. Do you have some judgments? Because we are making a submission that the High Court could not hear points, but the same could be heard by the Supreme Court under Article 136. Why High Court could not hear this arguments?
The council seek ignorance of the fact and apologize for that. Was not aware of the facts, so the council apologized on the fact.
अच्छा ये जो आपका इशू नंबर 4 है इसमें
Would we deal?
अच्छा 1 2 भी करते
Yes, yes. If the council has no further, bench has no further questions, the council may proceed. Thank you. Thank you, Lord.
Am I sufficiently audible? Sufficiently audible. Greetings to bench. This is co-counsel, speaker 2. I'll be dealing with issue number 3 and issue number 4. May it please the court, I'll start with issue number 3 with the due permission of the bench. Much obliged, your option. The issue 3 states whether the restriction imposed by college can be justified as reasonable restriction within the meaning of Article 19, Clause 2. The council will be presenting 3 assertions to prove the point, your lordship. Firstly, the absence of clear ground under Article 19, Clause 2. Secondly, the absence of...
Can you read Article 19? Article 19 2.
You have the statute with yourself.
Yes, your lordship. I'll read the... firstly, I was just...
Can you start with Article 19?
Yes, your lordship. Article 19, Clause 2. Nothing in subclause A of Clause 1 shall affect the operation of any existing law or prevent the state from making any law insofar as law imposes reasonable restrictions on the exercise of right conferred by the said clause in the interest of sovereignty and integrity of India and security of the India, friendly relation with foreign states, public order, decency or morality, or in relation to contempt of court, defamation, or incitement of an offence, your lordship.
So how it is relevant to you?
As my co-counsel already explained, that there is infringement of fundamental right of Article 19, Clause 1, A, that is freedom of speech and expression, and Article 21, that is liberty of the student and privacy of the student.
Can you read Article 19 1?
Yes, your lordship. That is freedom of speech and expression, your lordship.
Read it.
The whole article, there is no any extension of it. The restriction, your lordship.
19A.
19 1 A.
1A.
It is freedom of speech and expression, and in the Bill Act there is no other explanation given for the same.
Listen to me. We'll start reading from the Article 19 from the top line to end. Start reading.
Certainly. Article 19, that is protection of certain rights regarding freedom of speech, etc. All citizens shall have the right A. to freedom of speech and expression, B. to assemble peacefully and without arms, C. to form associations or unions or cooperative societies, D. to move freely throughout the territories of India, E. to reside and settle in any part of territory of India, G. to practice any profession or to carry on any occupation, trade or business, your options. The restrictions as well.
अब इसमें से कौन सा वायलेशन है आपका?
Article 19(1)(a), that is freedom of speech and expression, your options.
ठीक है.
How is it a violation?
As the circular restricts the usage of social media completely, and also
You know the issue pretty well. How do you think it is a violation of the fundamental right?
yes, your lordship, as it restricts the students to express their viewpoints, which they were using for expressing their viewpoints and to connect with the public and to spread. To take part in debates, public speaking, and expression of opinions, and to spread the ideas of the students as well. It also infringes the right of the students because it will infringe the personal use of the mobile phones, as it was also recognized in United Nations Human Rights Council that right to access mobile phones and internet is a fundamental right, your lordships. Let me state it exactly. I found the right to access the internet is a
What are you
human.
referring to?
I'm explaining the right
So you just mentioned UDHR. What are you referring to?
that in access to internet is also a fundamental right, your lordship.
Under which article of the UDHR?
Article it is not clearly mentioned in Indian legislation, but in Anuradha Basin versus Union of India, it was
You
recognized.
just mentioned United Nations.
Yes, your lordship. Human Rights Council of United Nations, your lordship.
Yes.
It has recognized that right to access internet is a fundamental freedom and a tool to ensure right to education.
But what are you citing? Is there a resolution? Is there some?
I'm citing the fundamental right of the student that has been infringed by the institution while restricting such impositions or restrictions, not allowing them to use the social media and internet during the premises, your lordships.
Okay, so somewhere in the UN it is just mentioned.
Yes, it has recognized the access to internet as a right.
Is it written in somewhere?
The exact authority.
What
Sorry,
are
your
you
lordship.
referring to? Yeah.
Yes, your lordship. The council seeks ignorance, your lordship. I cannot exactly point out that.
All right.
Much obliged, your lordship. So in that way, also the college is intervening in the personal usage of the students and their personal devices. Students using personal devices for all the other purposes as well to access educational resources and educational sites like Swayam portal and other educational resources available, which is the need of the hour to stay connected to the world and to the atmosphere. It will not, the discipline cannot restrict the students' right to access such resources, and therefore restricting this right to use personal devices during college hour will also lead to infringement of students' right.
Excuse me. You read the Article 19, you read the ABCD. Now read the last part, which is most important, restriction.
Reasonable restriction, your lordship.
Read that. Like, read that complete.
Oh, certainly, your lordship. Article 19, Clause 2. Nothing in subclause A of Clause 1 shall affect the operation of any existing law or prevent the state from making any law insofar as such law imposes reasonable restrictions on the exercise of the right conferred by the said subclause in the interest of sovereignty and integrity of India and security of the state, friendly relation with the foreign state, public order, decency or morality, or in relation to contempt of court, defamation or incitement of an offence. The Article 19, the reasonable restriction clause states that it is the court and not the legislature which has to judge finally whether restriction is reasonable or not.
That is the most important point. See, this is what we all are asking. Now repeat that again.
Okay, your lordship. Reasonable restriction. It is the court and not the legislature which has to judge finally whether a restriction is reasonable or not.
So that what that means to me? That means, as per us, no right is absolute. Okay, do you understand that?
Yes, your lordship. Certainly.
You have to explain now that it is not an absolute right. So whether it is a
fundamental right. In the present case, the restriction is not reasonable because it is arbitrary and excessive in nature, Your Lordship. Arbitrary because no explicit authority is there to particularly restrict the fundamental rights explicitly stated in under Article 19 clause 2 because it is nowhere
So
stated that.
your contention. That is your contention. That it is a violation of fundamental rights.
Okay,
Yeah.
okay, Your Lordship.
Yes.
And it is excessive in nature because, as the college states, it is to curb the misuse and to maintain the discipline and decorum of the institution, Your Lordship.
Yes.
But is it reasonable to restrict the usage of social media and personal uses absolutely just to ensure the discipline in the campus? Because there are less restrictive alternatives available for such objectives, such as restricting the usage of mobile phones and social media strictly during the lectures and instructional hours. Secondly, making such guidelines and regulations which particularly monitors the use in the rightful and the reasonable usage of the mobile phones and social media, Your Lordships. And thirdly, by organizing such counseling sessions and awareness camps that would enlighten the students on ethical use or the reasonable uses of such platforms and making the best use of it. So there are ample of restrictive, least restrictive options available.
Good that you pointed out. Now see, what is the context of this case? Mr. R was making reels. The
Yes,
context of the case,
Yes, sir.
he was putting it on social media. Fine. What does the circular says? That no use of social media and mobile phone during
Yes,
college hours. So there is no restriction. The use before and after college is permissible. There is no blanket ban on the use of social media and
Personal devices during
absolutely. So you have to explain now us this ban during the college hours. Where it is a context, it is very categorically mentioned that you are making reels and putting it on social media. So whether it is part of your curriculum, whether it is lawful, you have to explain that. Okay?
Yes, Your Lordship.
You're saying that the laws are draconian, but we don't find it that. We see that guidelines that the institution has made. These are now convince us.
Okay, Your Lordship. The usage of social media is not only for the fun purpose here. Social media is not only for the fun purpose here, but the students also use it to stay connected with the outer world because there are platforms that enlighten the students in many ways. It is upon the students' discretion to use the platform in a particular way. The platforms like WhatsApp, Gmails and emails, and other media platforms comes under social media as well. And these platforms are also used for sharing information and providing the educational advances or connecting with the larger audience. Therefore, the usage of social media can also be done in a positive manner. The need of the hour is to guide the students and to make them understand the responsible usage of such medias rather than restricting the usage completely, because now we are living in an age which is completely based on information and technology, and usage of train the student and to bring make the foundation of the students strong so that they can be able to adapt to such changes as per the requirement of the hour. So rather than completely prohibiting the usage, restrictions and monitoring would serve the same purpose, Your Lordships.
See, for example, you have also quoted test of proportionality.
Yes, Your Lordship.
This is one student hour. Fine, the whole class start making reels and posting posts on social media. What do you think? It is logical? It is reasonable?
That too during the college hours.
So you explain that to us.
Yes, Your Lordship. But the contention here is not only restricted to the making reels and all that. it is also about the freedom of expression, speech and expression. Due to troubles or due to actions of few students, the whole
Taste of proportionality. You have quoted it.
yes,
Read
Your
it.
Lordship.
Just you have to address that. See, there is a law we are discussing.
Yes.
Don't be busy. Read that test of proportionality.
Okay, Your Lordship. Test of proportionality sets that there should be a there should not be any least restrictive alternative available that the action taken. In the present case, the restriction is not narrowly tailored to deal with the issue as uh, other alternatives could have served the same purpose and due
Issue number 4. Is there any specific guideline issued by the university regarding meeting rules, regarding framing rules? इस बारे में जो आपके कॉलेज ने जो सर्कुलर जारी करा उसके बारे में कोई गाइडलाइन यूनिवर्सिटी की कोई एक्ट के अंदर कुछ प्रोविजंस हैं क्या कि वो ऐसी गाइडलाइन बना सकते हैं यूनिवर्सिटी?
Yes, Your Lordship.
ये आपका इशू नंबर 4 यही है ना?
Yes, Your
इस
Lordship.
बारे में
I would like to refer to YV versus Kendra Vidyalaya 2025. It's a High Court judgment, Delhi High Court judgment. It's YV versus Kendra Vidyalaya and others. Page number 18 of the memorial. Delhi High Court's guidelines and actions.
क्या बोलती है गाइडलाइन?
It clearly states, as a matter of policy, students should not be barred from carrying smartphones to school, but use the smartphones must be regulated and monitored. The students must the college must educate the students on responsible online behavior, digital manner, and ethical use of smartphones. Students must be counseled that high level of screen time and social media engagement and cyberbullying would lead to their
गाइडलाइंस क्या कहती है यूनिवर्सिटी?
that we don't have to restrict the usage of the phones completely, but we have to regulate and make them aware of the responsible use.
But what about the right of the institution to frame such guidelines?
The institution has right to frame guidelines, but rather than making such guidelines, they're completely banning the particular usage. So the request, sorry, Lord.
Yes, carry on.
The request of the council is the same only to regulate and to issue such guidelines which are less restrictive in nature and serving the exact purpose, Your Lordships.
So it means आपका कहना है कि यूनिवर्सिटी जो है वो गाइडलाइन फ्रेम कर सकती है.
Yes, Your Lordship.
तो यूनिवर्सिटी ने जो गाइडलाइन फ्रेम करी है विद इन द
Ambit of the authority.
हाँ एम्बिट ऑफ लॉ करी है. ठीक. और इसमें अब और क्या हो सकता है?
Yes, Your Lordship. But we are contending on the fact that they cannot restrict the fundamental use completely because it is only the law that can restrict the usage or that could restrict the fundamental rights. And in the present case, the due procedure has not been followed because the freedom of speech is not absolute, but restrictions must be accompanied by procedural guarantees, Your Lordship. And in the present case, no prior notification or warnings had been given to the students. It was a direct restriction and absolute in nature. Also, there was no opportunity was given to the students to show cause or to present their opinion before.
Is it necessary?
No, but the question involves the fundamental right of the students, Your Lordship. So, in the present case, it is.
If the institution had the authority, they framed such guidelines, is it necessary for them to hear out the students?
No, Your Lordship, it is not a necessary contention, but still, because the question involves fundamental rights, so there needs to be a procedural as per the natural justice. As per the natural justice, there must be a procedure followed, which should involve both the parties who are getting affected, because the rights of the students is involved, and the students are also majors. They cannot be regulated under locus parendi, that is the authority of the institute to completely regulate the restrictions. In school, it is admissible and it is acceptable, but in colleges, the students are of majority and have the reasonableness to understand the consequences of their acts, and they can be trained and counseled for the intelligible usage of the things, Your Lordships. That's why the council requests to counsel the students and impose proper restrictions and least restrictions and frame the reasonable guidelines within the constitutional framework, Your Lordships.
And that is a more appropriate approach.
Much
When you
obliged.
request and when you seek the improvisation of the circular. So that's all. Anything else you want to say?
Yes, Your Lordship, that's the all we have to submit. May I proceed to the prayers?
Yes.
In the light of the issues raised and arguments advanced and authorities cited, it is most humbly requested to the bench that to grant special leave to appeal and set aside the imposed order by High Court bench of law, declare the circular arbitrary and infringement of fundamental rights and suggest less restrictive alternatives, issue guidelines for regulation of social media and personal devices to students within educational institution, and any other relief that the Honorable Supreme Court may deems fit to. Much obliged. It's a pleasure to present the argument before the bench. That's it, Your Lordship. Thank you.
The council seeks permission to address the honorable bench collectively as your lordships. Much obliged. If it may please the court, the council is appearing on the behalf of the respondents in the matter of National Arav Mehta and others versus National Law College, Indore. In response to the special leave petition filed by the appellants before the honorable court. The council bench will be addressing issues 1 and 2 while in the next 22 minutes, while my co-counsel shall be addressing issue number 3 and 4 in the next 20 minutes, and 3 minutes are reserved for the rebuttal rounds. Before coming into arguments, the council would like to humbly seek the liberty of the honorable bench to amend the cause title of the present case. Lordships, as the appellants have failed to justify why the college is a publicly funded institution, why the college is stayed under definition of Article Clause 12, and why such fundamental rights have to be enforced against such a state. Maintainability.
Cost title.
Yes, sir. Lordships, regarding the cost title, Arav Mehta and others versus National Law College. That's the amendment what we are seeking before the honorable court.
They made state a part.
The council seeks permission to state the facts of the case in the brief. Just fine. Lordships, a circular was issued in the present case by the National Law College Indore in order to maintain the discipline and improve academic focus and prevent the misuse of social media, which was evidently being misused by the student. It had been provided by the proposition itself. Which the circular reasonably restricted the use of social media, personal devices, and colleges Wi-Fi within the college premises and within throughout the instructional arts blocks. Lordships, which was later upheld by the College Grievance Redressal Commission when it was challenged before it by the appellants, stating that the college had the authority and the college had acted within the authority to enforce such a circular, which the decision of the college committee was later challenged before the Honorable High Court of the Madhya Pradesh, which has while dismissing the petitions on merits after hearing both the parties, they have concluded and they have reasoned the judgment that state the college. The college was within the authority, and the restriction imposed was a reasonable restriction under Article 19 Clause 2.
So first thing first, whether your college is a college or a university.
Lordship, the preposition does not clarify whether it is a college or
you are presenting them.
Yes.
You should know it.
Lordships, as per the clarifications, the status of the college is exhaustive in its sense, and
In the National Law College, Indore is a publicly funded institution. It neither delineates itself as a university
So
nor
what is
to
a publicly funded?
What's a publicly funded? Where the funds of the financials have been incurred by public. It does not. Yes, Lordship.
Public? What do you mean by that?
Lordship, it does not specify a governmentally publicly funded institution. It does not.
The name of college is publicly funded.
The present government New Law College is of government.
What is it not? What do you want to say?
Yes.
Publicly funded से आपका मतलब क्या है?
Publicly funded institution is an institution which the financials of that institution are regulated by other
Public at large.
Public at large by the state.
By the state. Right.
Yes, Lordship.
So this is.
So you agree to this? This is a government funded college. Okay.
Lordship, it is not being prescribed by the
Fine. Lead to that. We are saying.
See, apart from that,
Yes, Lordship.
can you hear me?
Yes.
So what is the issue?
Yes.
The issue, the college and the state, the duty is to address the grievance of the student. Right. What is the grievance?
Lordship, the grievance is that we as a institution has restricted their rights as per their contentions. It is their contention, Lordship. It is not, and the Honorable High Court has adjudicated the matter and upheld it.
You have a grievance committee, as you stated.
Yes. Yes.
So what do you do in the grievance committee?
Lordship, we seek the grievances of the students and we seek to resolve the grievances while upholding the larger interest of the students.
So if you ask all the students,
Yes.
what is everybody raise hands who wants to have a ban, and everybody raise hand, don't raise hand who doesn't want to have ban. What do you think the student must have done?
Lordship, major of the students were influenced by a spread of actual evidence of spread of misinformation as well as of cyberbullying. Lordship, students were being influenced by the which.
It is a pity that such a petty thing has
Yes.
come down to this.
Yes. Yes, Lordship. That is why I am arguing on issue number 1 that the present petition does not is not maintainable before the honorable bench.
Yes, sir.
Yes, Lordship. Lordship, on the arguments on issue number 1, I would like to put forward my 4 contentions before the honorable bench. Firstly, Lordship, there is no substantial question of law involved in the present case. Lordship, as per the contentions of my learned co-counsel, the substantial question of law which they have put forward that the colleges infringed the fundamental rights of the students. Lordship, infringement of fundamental right does not cannot be standard as a substantial question of law. It may be a mere a question of law. Lordship, okay.
You think a question relating to fundamental rights is not a substantial question of law?
Lordships, I'm not denying to the facts. I would like to put forward in my. I will and answer your query in my later arguments within the
आप
arguments.
इस बात को explain करें कि petition maintainable कैसे नहीं है?
Okay, Lordships. Firstly, I would like to state the grounds on which I am contending that the petition is not maintainable.
See, what is asking answer that is what. What we are asking, that question you can address.
Okay.
Leave apart what you want to say. Okay.
Lordships, the petition.
In your own words.
So the petition is not maintainable before the honorable court. There's no substantial question of law involved in the present case. No miscarriage of justice has been inferred by the honorable judgment of the honorable high court. Lordships, there are equally effective, unexhausted remedies that exist in the present case, which the appellants could have sorted rather than filing a.
What remedies?
Lordships, they, as per the high court rules, they could not have filed a review appeal on the present matter. And the present matter,
Are you stating something or are you questioning us?
Merely stating
that they couldn't have gone into review.
Lordship, as per the High Court rules, under the writ, when a matter of such kind is adjudicated by the Honorable High Court, it is not contended that a review petition is accepted by the Honorable High Court in such cases, Lordship. Under other appellate jurisdiction, but the jurisdiction of Article 136, which is the extraordinary and discretionary jurisdiction of the Honorable Supreme Court does not extend
ऐसा कोई जजमेंट है आपके फेवर में जो ये कहता है कि आप डायरेक्टली एसएलपी फाइल नहीं कर सकते?
No, Lordship, does not say it, but I have stated some judgments in my compendium also. Lordship, if you refer to the judgment, the flag number 10, which I have, which is not in the compendium, I have separately provided it. It is the judgment of Preetham Singh versus the state. If your Lordship, with
क्या है जजमेंट में?
Lordships, in the paragraph number, it has been held that the court will not grant special leave petition unless it is shown that exceptional and special circumstances exist and that substantial injustice has been done, and the case questions the features of sufficient gravity to warrant a review of the decision appealed against. Lordships, in the present case, High Court has rightfully adjudicated the matters on its merits after hearing both the parties. It had adhered to the principles of natural justices as well as they have provided reasons for the restriction, and which they have regarded as a reasonable restriction.
So you're basically making their point that they couldn't have approached the High Court.
No, I'm not saying. I'm saying that the High Court has rightfully had adjudicated the matter, and the matter has been settled as per the judgments. They have appealed against it, but the appropriate jurisdiction under Article 136 is not maintainable because alternate remedy they could have approached the Honorable High Court under other appellate jurisdictions.
Where's
Yes,
the jurisdiction of the High Court?
Which
What are
rules?
the provisions? What are the availability?
Lordship, the council
What is
is
the appellate remedy?
What is the alternate remedy? Lordship, there are other appellate jurisdiction of the Honorable Bench of the Honorable Court, in which they hear the matters regarding the Constitution in appellate jurisdiction, like under Article 132. They hear matters regarding the constitutional matters where interpretation of Constitution is provided. They could have approached Lordships. They should have approached the Honorable Bench, not in the SLP but in other appellate jurisdictions.
Which jurisdiction?
Lordships, that is as per the discretion of the appellants. It is not
There is
as
no discretion.
Can you quote some law in this regard?
yes, sir.
Can you quote some law in this regard? Any
Lordships,
article
Article
or
122 is
law?
another appellate jurisdiction in which the Honorable Bench is duly empowered and vested with the power to hear appeals on civil matters, criminal matters, and other matters, which covers the constitutional matter itself. Lordships. If the present case is regarding the constitutional matter, the appeal could have been provided in the Article 122 itself. Lordships. Fourthly, Lordships.
One more question is there.
Yes, Lordship.
There is no substantial question of law involved.
Yes, Lordships. Regarding that, I was.
The question of law in this substantial question of law and question of law. How can you differentiate between them?
Okay, Lordships. Lordships.
First of all, there is a substantial question of law. There is a question of law. दोनों में से क्या involved है इसके अंदर?
Lordships, in the present case, a question of law is involved. It does not identifies or identifies as a substantial question of law. It is merely a question of law, and under Article 136, which is an extraordinary jurisdiction, under Article 136, the court is empowered to, as per the judgment, I have quoted Preetham Singh judgment, extraordinary jurisdiction under extraordinary.
Yes. Your Preetham Singh judgment which you have quoted.
Yes.
See, first you understand. The Preetham Singh judgment is related to a criminal case where a person has killed someone,
Yes.
and then he is approached on the Supreme Court, stating that there is a jurisdiction. The Supreme Court is said, as you have quoted in the last paragraph, 8 number, and it has to be in exceptional circumstances. Okay?
Yes. Their individual interests. And Lordships, there is a judgment which I have quoted in the flag number 2, which is a judgment of Fatima Taslim versus State of Kerala, flag number 2. In the compendium, flag number 2. This is a recent judgment of 2017. It has been held by this Honorable Supreme Court when an individual interest and a larger interest, then the paramount larger interest must yield to the individual interest. Lordships. Okay. That is why no substantial question of law is involved. Okay, Lordship. Lordship, the present petition is not maintainable before the Honorable Court. The council like to proceed to the arguments and issue petition, which is whether the circular issued by the college banning the use of social media during college hour amounts to the violation of fundamental rights of Article 19. Lordships, firstly, Lordships, the freedom of speech, I would like to put forward the contentions in two parts. Firstly, the freedom of speech and expression is not an absolute freedom, and it has to be exercised with regards to the paramount interest of state and other community at large. Secondly, Lordship, the circular should be treated as an internal instruction intended to maintain discipline rather than a violation of fundamental right, which I will consider. Firstly, Lordship, the right alleged to have been infringed in the present case is the fundamental right of speech and expression, which is not an absolute right, which has also been accepted by my learned co-counsel. This right is a restricted right.
Now you read the Article 19.
Yes, Lordship. Lordship, can I take the?
What are the restrictions?
Lordship, the restrictions on only the grounds?
Yes.
Okay. Lordship, the restrictions are the security of state-friendly relations with foreign states.
No, slow down.
Okay, Lordship.
Yes,
Firstly is the security of the state.
Yes.
Friendly relations with foreign states.
Yes.
Public order.
Yes.
Decency and morality.
Yes.
And in relation to contempt of court, defamation, and incitement to an offence.
Now you tell me, which one is it infringing?
Lordships, in the present case, a reasonable restriction has been put forward in the on the speech of expression under the grounds of public order. In the present case, the reasonable restrictions have been restricted the right of. Lordships, the public order is an expression of wide connotations.
Yes.
Wide connotation signifies state of tranquility which prevails among the members.
So you're reading out of a commentary. You're not referring to a case.
No, Lordships, this has been mentioned. Okay, Lordships.
Yeah. So what is the citation?
Lordships,
if you're reading a commentary, just tell us that you're reading a commentary.
Yes, Lordships, I'm reading a commentary of.
All right.
Lordships, the public order is an expression of wide connotation that signifies the state of tranquility which prevails among the members of political society as a result of internal regulation enforced by the government or which they have established. Lordships, in the next line, in the next para, it has been in the interest of public order. Any restriction imposed in the interest of public order include not only.
So you need to interpret it literally. Here it mentions peace, it mentions tranquility. All of these things relating to the public order are meant to maintain the peace and harmony of the society. Was that endangered by the use of social media by the students?
Yes, Lordships. There have been evident recent examples where the spread of misinformation and misinformation has led to
but in
disturbance of
public. I don't see any.
There have been past incidents of cyberbullying and spread of misinformation.
Okay.
Yes, Lordships. And the spread of misinformation can lead to disturbance of public peace as well as tranquility. It has been evident in the recent cases, in the recent years. Lordships, the council would like to argue issue number 2 by stating, if you refer to Lordship, the freedom of speech alleged to have been infringed by the appellants is not an absolute right. It must be regulated, controlled, and reconciled with the exercise of similar rights of other individuals. Lordships, if you kindly refer to LIC versus Manu D. Bhai Shah, which I have provided in the compendium paragraph in the flag number 3rd. In the paragraph number 23, it has been mentioned that every right has a corresponding duty and an obligation, so as the fundamental right of speech and expression, which carries with it lots of certain responsibility towards fellow citizens have to be catered when you are exercising the fundamental right of speech and expression. The person exercising must remain conscious that other individuals have similar rights. Not just when this right has been exercised to spread misinformation. When spread of misinformation has led to an exercise of a right, it cannot be regarded as having conscious of other individuals having similar rights.
Misinformation.
The college has the autonomy and the authority within the institution. It can impose a reasonable restriction within the institution. The council would like an extension of time. The college has the authority within its institution. That is why they have justified the restriction within its institution.
So you're saying that they did whatever they could have. Is that what you're saying?
Lordships, to prevent the misuse, which would lead to students being endangered by the offences like cyberbullying, it is a obligation.
They have only imposed restrictions up to the college hours. That's why they did it.
Lordships, that was yes, Lordships.
All right.
Lordships, secondly, the institution concerned here is an educational institution, which also confers a right to establish, administer education institution under Article 19(1)(c), which has been recognized by the TMFI 11th bench judgment, which I have also provided in my compendium, flag number 4. Paragraph number 450. It has been accepted by the Honorable Court that right to administer and establish an education institution is a right recognized under Article 19 clause 1.
Yes, we know that.
Yes, Lordships. Lordships, the main purpose for which the autonomy has been granted to the education institutions are so that they can manage their internal affairs as to ensure their basic functions, which is to impart education, which is affecting Lordships when students are Lordships, it is an evident fact which I have also mentioned in my memorial. As per the report of UNESCO World Education Block, they have researched the para number 18, page number 16.
Yes.
Lordships, on line number 4, I have reading.
So that's okay.
Personal devices of students are a major source of distraction nowadays, which negatively impacts the student's ability to focus. A study has found that it can take up to 20 minutes to refocus in a study after actively engaging in a non-academic activity. Lordships, if the students actively engages on a non-academic activity which involves usage of personal devices, it can lead to the students being poorly focused in the education, which is also the object of the college to ensure that.
This plan of yours is for all the years or only for the first year of college?
Lordships, the moot preposition is silent on the particular fact.
Because as the condition of the moot preposition says, the Arav is the student of first year. And the first year students have approached this court. So it is only applicable to first year path. The rest of the students.
Lordships engages on social media, posting blogs and.
No, you agree to this point. He is a student of first year.
Yes, Lordships. It is provided by the institution.
That means he is just enrolled to the institution. He is new to the institution. Right? So don't you think that institution is a duty toward the newcomers? They have to morally and emotionally support.
Lordships, the present circular has been enforced in the interest of students only. The students of the institution.
That's what we need to know.
Yes.
Because he is the first year student, as it is narrated in the moot proposition.
Indeed.
See, first year and fifth year student is a difference. Make it. That's what we are asking you. Do you understand? This is the blanket. So this is for the only first year or first year student. You understand? They are newcomers to the institute. They are new. they don't have a habit of understanding law. Maybe there is a reasons for them indulging in the social media. Have you reasons? Have you assigned some reasons to them? That's what we are asking.
We have, as per the Moot proposition, have provided just reasons, which includes there have been evident incidents of misuse of social media, which had led to the students being affected by the cyberbullying like offences. Arav is a first year law student. He has just entered the law school, and while is also mentioned by the proposition that the college has a reputed institution, uh, which if a spread of misinformation and the college is the source from where the spread of misinformation has been happened, it would also affect the reputation of the college as well as the interest of the students.
Good, good. So that means he is suffering because the earlier students have done the misdeeds. Because as you said that earlier there was some misinformation. That means he doesn't. The Mr. Arav has not done. The earlier students who were passed out must have done something. So he is paying the price for the deeds of someone else.
Since Arav Mehta personally also engages on social media and posts opinions, which has a tendency that that it also could lead to misinformation on the particular fact. Also, it has been held by the various courts of the country that discipline is a paramount asset of an education institution, and within an education institution, it is an internal affair to manage its discipline in order to ensure orderly administration and hence to ensure the basic functions, which is education in the particular. Also, in the Indulekha judgment, it has been held that individual rights should be subjected to the code of conduct. It has been flag number 9, paragraph number 19 of the judgment. Discipline being the paramount asset of an education institution, and any compromise made in a matter of maintaining discipline could result in disastrous and deleterious effects on the society. Also, the council seeks extension of time.
To conclude it. Conclude.
Okay, Lordships. Lordships, the present circular was dated. Present circular was issued as an instructional regulations in order to maintenance of discipline, which which the education institution has an inherent authority to manage, and also to in the interest of students to which is also a statutory obligation and a duty of education institution to ensure the safety of the students studying in it. And Lordships, they were being subject to offences, and it was an duty of the education institution to ensure that the students are well within the facts. Lordships, the circular does not amount to any violation of fundamental rights, and has to be treated as an internal regulation, which was furthered in the maintenance of discipline and orderly administration of the institution, which the subject which the appellants were subject to. Lordships,
Do you have some issues left?
Lordships, we have two issues left. Issue number 3 and 4, which my co-counsel will be taking.
All right.
If it pleases the bench, the council seeks permission to move further with issue 3 and 4, of which the issue 3 is whether the restriction imposed by college can be justified as a reasonable whether the restriction imposed by the college can be justified as a reasonable restriction under Article 19. My lords, as we all know that no freedom is absolute, so does the Article 19. Article 19.1 is subjected to the Article 19.2, which states that the state is empowered to impose reasonable restriction on the various laws mentioned in it. My lords, in the present case, the legal framework of India also uphold in the Moot proposition, para number 3, uphold this legitimate role of state, safeguarding the collective interest through these narrowly tailored forms. In para number 3, Moot proposition. So the question again of can the circular be justified as a reasonable restriction? Article 92 itself, which in order to be a restriction held as a reasonable restriction. which is whether the restriction must have to be on the grounds mentioned in the Article 19.2, which the circular satisfy as the restriction is imposed on the ground of public order. My lords, the present case has the college has reported the leading to the cyberbullying and other deleterious effect to the students, which is mentioned in the moot proposition parameter 7. My lords, the college has reported it. My lords, it is to be noted that the misinformation has the utmost tendency to cause the panic and the disturbance of public order, of which is ultimately synonymous to the disturbance of public safety. My lords, in this context, I have a judgment of so at flag number 5. My lords, on page number 2nd, the Supreme Court has also held in the present case that in the present case, my lords, the Supreme Court has yes, has held that the fake news spreads faster and more easily than a virus and is just as dangerous as. In the present case, my lord, a mere misinformation has led to the migration, which has caused the utmost panic and which ultimately led to the death of the migrants. My lords, the spread of misinformation can be overlooked, and in the light of this, the circular has been issued under the Article 92 on the ground of public order. Thus, my lord, coming to the second essential, my lord, restriction to be reasonable, it has to be reasonable. It has to be reasonable as per the phrase of reasonable restriction incorporated in the Article 92. For this, my lord, the Honorable Court, in the case of VG Rao, I would like to present this statement because it can read. Okay. My lords, in the present case, the Honorable Apex Court has previously provided for the grounds or the parameters on which a reasonableness can be judged. Though there is not an abstract pattern and it depends on case to case, the court has opined that these parameters must enter the judicial verdict at the end, which are, my lords, the need restricted by the state upon the grounds mentioned in the Article 19. Second, my lord, the underlying purpose for restriction imposed. The sole purpose of the restriction imposed was to cater the general interest of students at large, which are at the stake because of the spread of misinformation. And we all know this, the spread of this misinformation and fake news travels with the speed of light in today's contemporary era. Coming to the extent and the urgency of evil sought to be remedied. My lords, the college, as previously has reported to the instances of misinformation and cyberbullying, and also previously discussed in the Alak Alok Srivastava case, that the misinformation has the utmost tendency to create a panic and disturbance, and thereby leading to the disruption of public order and safety. Thus, to ensure the public safety within the campus premises, the college has the utmost authority to do so. Coming to the next parameter, my lord, the disproportion of imposition. My lord, there is no any disproportion as it is the ban of social media, not of the right of education over the internet. They are empowered within the campus to use Manupada there as they have mentioned. It is only the ban of social media within the instruction hours of the college.
But isn't using social media their inherent fundamental right?
My lords, only the mode of expression has been moderated by the college in the present case, not the whole right itself. Only the mode of expression. Social media is just a mere mode of expression. Can be used as a font of education, my lords. There are various other resources for the education. Social media is just for entertainment. If we prima facie look at it.
That is a debatable point.
Yes, my lord.
Social media is for entertainment or education.
Could have a separate view.
Okay, indeed, my lord. Coming to the next point, my lord, the prevailing situation at the current time, as we all know, the college has faced the.
आप ये बताइए आर्टिकल 19 का वायलेशन कैसे है?
Yes, my lord.
आपने रेस्ट्रिक्ट किया है ना?
Yes, my lord.
उनको तो रेस्ट्रिक्ट किया है तो आर्टिकल 19 का जो बच्चा है वो उसका फ्रीडम ऑफ स्पीच का वायलेशन नहीं हो रहा. कैसे नहीं हो रहा?
My lords, it is their contention. As college, we have a duty to cater the interest of student. In the light of that reason, the college has imposed the circular. That's why. And my lords, this circular is not excessive and is a narrowly tailored regulation only which is overweighted by the broader institutional and societal benefit it seeks to achieve with the circular as against the interest of individual, thereby making the circular to be justified under the Article 19 as a reasonable restriction. If it pleases my lord, the council seeks permission to move further with issue 4. which is whether an education institution has the authority to regulate or restrict the use of personal devices within the campus premises during the instruction hours. My lord, as we all know, the college, the TMFI judgment, the Apex Code is laid down as provided that the college has the right to administer its own affairs under the Article 19(1)(g). My lords, Article 19 is not a blank check, which can allow appellant to encroach upon similar rights guaranteed to the institution under the Article 19 itself. Too, they cannot seek imposition of individual rights against the larger rights of institution. And my lords, I would like you to refer the Unni Raja judgment at flag number 6, para number 17.
Yes,
My lord, the present judgment which I am contesting has come along with the help of various past Apex Court rulings, which in which
what was the context?
Yes, my lord.
What was this case?
My lord, in the Unni Raja, wait. The counting correct. 1 minute.
You haven't read the judgments.
No, my lord, the facts and will.
So you're just picking out pieces from a paragraph and just citing.
No, my lord, I would like just to confirm.
That's why he was citing one.
No, my lord, I would just like to confirm the facts that. I would just like to confirm the facts.
Yes, yes.
My lords, in the context of case is that in the present case, the appellant in that Unni Raja case, the appellant was restricted for giving the examinations of MBBS.
Are we bound with this? This is a single bench judgment of High Court.
My lords,
We don't need to look at this.
My lords, it is upon the utmost discretion of the bench. The council is only trying
Apart
to.
from this, anything else you have?
Presently, my lords, the council is not equipped with the judgment of Apex Code in the present matter. The council is only trying to persuade the bench towards a direction which has been came
Whatever is
forward.
stated, we are already agreeing to whatever is stated in this case.
Yes, my lord.
That the head of the institution has a right to do such acts which are necessary in his opinion to maintain discipline in the institution. We fully agree to it.
Yes, my lord.
But how can you say that a ban on use of mobile phones or social media is not infringement of the fundamental rights of the students which are studying in the college? That's what we are asking you.
My lords, as you have acknowledged that the education head has the authority to regulate the conduct of students.
But does he have the authority to enter into somebody's mobile phone?
My lords, this the controlling of conduct is synonymous to controlling of their Article 21, the right to life and privacy, to an extent, and Article 21 supersedes the Article 19. If Article 21 can be controlled, not abrogated by the college, if it can be controlled, then it automatically enables the college to control the Article 19 too. My lord. 19.
No, I didn't get your point. Come on,
My lords, as the bench has acknowledged that the head of the institution has the authority to maintain discipline and the conduct of students. My lords, conduct is one thing which is restricted to oneself. If the college has the authority to
you were mentioning Article 21.
Yes, my lord, I was coming
that
to it. The maintenance of conduct does fall upon the private space of the appellant in the present case. While upon entering the college on the process of admission, the college, the appellants or the other students acknowledge that they are bound to follow the conduct of the college, which has been upheld in the case of my lord.
So you are saying that any guidelines that the college frames is bound upon students?
Yes, my lord.
Whether it's draconian or not, that is for you to decide.
Yes, my lord.
Like whether it's very stringent, very strict.
My lord, the present restriction is not stringent. It is again their contention. The ban is not of absolute nature. They are free to do anything after college hours. If they are within the campus premises, it is the duty of education institution to look upon them.
Go on.
Yes, my lord. Thus, Malos once admitted they cannot. They are agreed that they are bound to the conduct laid down by the college and education institution. And Malos, the similar contention has been followed in the case of Manu Wilson at flag number 7, para number 5. Again, this is a judgment of Kerala High Court, Malad.
Did you read this?
Yes, Malad. Malad, in the present case, the bench has provided it, has enabled that the institution to be required to be equipped with the adequate authority to maintain the discipline, Malad.
Who are
Malad,
who are we?
Honorable Ethics Court, Malad. The present judgment of Manu Wilson has came forward with the help of the past apex court rulings like MS Devandrappa and others, upon which the case has been adjudicated, and the council is only trying to persuade the bench in that direction that the that the college has the authority to conduct the to regulate the conduct of the students.
So that is a very good established principle that
Yes,
the college has the authority to issue guidelines.
Yes, madam.
The question is whether the guidelines are admissible or not.
Well, they are bound by it, as it is not something which absolutely encroaches on their fundamental.
So that is for us to decide.
No, sorry, indeed, your lordship, the council seeks apology for that, and yes, my lordship, they are bound by it because the ban is not of absolute nature. They are free to do anything in the after the college hours, and it is also need to be mentioned that it is only the leisure time which has a tendency of spreading of misinformation, and as has been contended by them, the article 19 has to be used in a positive nature. The positive nature can in not any sense can warrant for that it cannot be misused for example like spreading the misinformation within the campus manner. That is why the present circular stands still, and thus, in the present case, the college has only acted in the exercise of constitutionally and judicially acknowledged rights while formulating the circular. Thereby, it is safe to conclude that the institution has the utmost authority to regulate and restrict the use of personal device within the campus premises during the instructional hours. Thus, my lords, if my lords are satisfied with the submission under Article 3, issue 3 and 4, the council seeks permission to move further with them. Wherefore, in the light of facts used, issues raised, authorities cited, and argument advanced, the counsel for respondent most humbly praised before the Honorable Supreme Court of India to be pleased and adjudged and declared that to dismiss the present special leave petition as devoid of being merits and award for the costs. And also adjudged and declared that the circular issued by college dated 10th of July 2025 to be declared infra violates the constitution and does not amount to any infringement of appellant's rights under Article 19 and 21 respectively. The restriction to also adjudge and declare that the restriction imposed by the college be justified as a reasonable restriction under the purview of Article 92. Affirm the authority of educational institutions, my lord, to regulate the use of personal devices within the campus premises and instructional hours, and my lords, pass any order or judgment declaring and upholding the judgment of the Honorable High Court of Madhya Pradesh, bench at Indore, and the decision put forward by the college grievance committee, thereby thereby making the circular constitutionally valid ab initio.
I have a question.
Yes, my lord.
Where you have stated that the fourth prayer.
Yes, my lord.
Yeah. Affirm the authority of educational institutions to regulate the use of personal devices within its premises during instructional hours. That's what you prayed for.
Yes.
Yeah. And what was the circular that you issued?
The circular provides for the restriction upon the use of social media during the college hours, 8 to 4 p.m.
So you also think that apart from the instructional hours, the use of social media should not be banned.
Yes, madam.
So you also agree to the fact, see. College hours and instructional hours are different, isn't it?
No, my lords, it is provided in the clarification, second clarification at 5th point. Define instructional hours. Instructional hours are synonymous with the college hours.
All right.
Yes, ma'am. Thus, and provide any other relief that the Honorable Supreme Court may please to grant in the interest of justice, equity, and good conscience, all of which is respectfully submitted. For this act of kindness, the respondent shall duty on forever. It is a pleasure to argue with the Honorable Bench.
Anything for rebuttal?
Am I audible? Yeah. Your Lordship, my learning opponent co-counsel has said in their arguments that there was no substantial question of law involved in the recent matter. But Your Lordship, a substantial matter of law is involved, as if the circular is upheld, it can be used by other institutes to restrict the fundamental rights of the students. Secondly, my learning opponent co-counsel used the term public order. Public order can't be used here. There is nothing like students harming the public order. The term public order is a big term used for peace, security, and tranquility of country. But in the recent matter, there is no such issues involved. Concluding with some of my questions from my opponent counsel, I would like a clarification from my opponent counsel that how a state can be made a party as college is acting within its ambit and not on government law. Secondly, the institute can punish the particular wrongdoer as the core principle which is put forward by the institute to implement circular is cyberbullying. So the institute can punish the particular wrongdoer and can take disciplinary actions against the wrongdoer. What's the need to implement the circular for all students, relying on the principle that all should not suffer because of one? With this, the council would like to sum up with the rebuttal. Much obliged.
Answer one thing. Haven't you asked them this is a school or a college? You are studying in a school or a college?
College.
So what is different in a school or college?
Your Lordship, in reference to the recent matter, the school has authority to restrict students regarding the personal devices and social media because the students in this school are not that adult and not at having that mental difference between how to use the social media correctly and can cause disturbance. But in the college, the students are adult and are well versed with the disciplinary measures of the authority. So in the recent matter, the only difference the council can see.
So you got the word adult. So you understand the meaning of it. What is the age of India to be adult?
18 years.
So the ban is on the persons who are above 18. So that's what you should have said. Okay?
Okay, certain. The council apologizes. Much obliged.
rebuttal का rebuttal. उसके बाद फिर आप करेंगे आखिरी अब.
Lordship, saving the time of the court, I would like to state one fact. They have mentioned that school and college, the stakeholders are different. The stakeholders in the school are minor students, and in the college they are major students. Lordship, so with regards to that, the usage of smartphones is also different. The usage of smartphone by a minor student who is studying in a school and a major student who is studying in college, the usage is different. It is more prone to other offences like cyberbullying and misinformation, which is why the present circular stands present circular stands as a reasonable restriction. Lordship, and it is they have mentioned about the punishment. If they can punish, there is no mention of the punitive damages or the punishments. And
See, understand. We have a law in India. There is a written constitution. If you say there is cyberbullying, there is a provision of Information Technology Act which governs. So there is a law where you can invoke it. Fine. There is a misinformation. there also you can invoke it. So, is there what their question is? And there is already a law in existence, and they are not minors; they are adults. So, can you restrict them in the name of in the name of?
The name of preventing the misuse or the
So
maintenance
that's
of
for you to justify. Okay, done.
Okay. Lordships, the college authority is not preventing, it is merely regulating in order to merely regulating the use of the smartphones for purposes which could not have led to the substantial questions. Thank you, Lordships. It was a pleasure arguing with you. Honorable Bench.
Order. अब Moot Court is over. सिर्फ relax है, ठीक है? कुलदीप कुछ कहना है तुझे?
नहीं सर आप
कह रही है.
you are the senior most here.
See, in my
Moot proposition is very good. थोड़ा सा आपको you need to understand the basics. ठीक है? And the constitution is a big document. It has everything and every coin has two sides. Preparation आपका अच्छा है, wonderful है, पर as चाणक्य ने कहा और बाकी में आपको जजमेंट पूरा पढ़ना है. ये जो व्हाट्सएप का ज्ञान है वन लाइनर सर्च करोगे तो उसका पूरा नहीं मिलेगा. जजमेंट जैसे पुट्टा स्वामी, कितने बजे जजमेंट पुट्टा स्वामी? तो 400 पढ़ने आपने किसी ने पढ़े? श्रेया सिंगल का वो लिखा है आपने कोट किया है. श्रेया सिंगल कोट पढ़ा किसी ने? क्या कहता है? तो ये जो जजमेंट्स है आप पढ़ोगे नहीं पूरा तो आप समझोगे नहीं पूरा, इसलिए आप ये जो बहस कर रहे हो ये ऊपरी स्तर के रहेगी. क्या रहेगी? सुपरफिशियली, शैलो. डेप्थ में तभी आएगा when you will read the constitution along with the application of it in context with the facts along with the citations. So this is a basic understanding. समझे? Problem is there. Understand the facts. Then what are the laws applicable to it? Then what is the court says about it? High Court, Supreme Court. Okay. Then in how do you fit that in your case and how do you support your side, the which side which you are arguing? Okay. So, बहुत patience का काम है and आपको gradually आ जाएगा. So there is so much improvisation you can do. Thank you so much for inviting us. क्या हम चारों जो हैं चारों I think school of law से ही हैं. Yes. That is we all for. I am like 2004 batch pass out और I think 2006
2008
और खाना क्यों हमारा बच गया?
This is see. So this is the beauty of the college and alumni and everything. We all are from the same school of law and from 20 years of 2004 to 2019.
Yes, our teachers as well. We have.
So this is the beauty of this profession. So, thank you so much.
अभी और बैठना है क्या? बचा है कुछ? बैठ जाइए प्लीज प्लीज सिट सब बैठ जाइए. क्लासरूम नहीं है.
रिजल्ट्स के लिए हमारे पास थोड़ा सा टाइम है, तो लेट्स हैव अ चैट. आपके कुछ क्वेश्चंस हो तो प्लीज ऑडियंस से भी, एनीबॉडी, एनी क्लैरिफिकेशन, एनी फीडबैक यू वांट, एनीथिंग.
हाँ हो जाओ बस.
हाँ प्लीज स्पीक प्लीज. मुझे लगा मैडम आप पूछ रहे हो.
जिसकी जो इच्छा हो. हाँ
सर मेरा एक क्वेश्चन ये था कि जो पब्लिकली फंडेड है और गवर्नमेंट फंडेड है, तो जो गवर्नमेंट फंडेड होता है
there is no distinction.
तो उसमें
There is no
बोथ आर द सेम थिंग्स. पब्लिक का अपना पैसा नहीं होता कुछ. पब्लिक सरकार का अपना पैसा कुछ भी नहीं होता है. सरकार का पैसा वही पैसा है जो पब्लिक का पैसा है. आवाज आ रही है पीछे तक क्या? पब्लिक फंडेड इट मींस गवर्नमेंट ग्रांट एडेड या गवर्नमेंट फंडेड कॉलेज. और आर्टिकल हाँ बोलो.
जैसे सर मतलब जो गवर्नमेंट फंडेड होता है उसमें बजट का भी कुछ ऐसा मेंशन रहता है और
नहीं, यहाँ पे वो इशू नहीं था. यहाँ पे इशू ये है कि जो आर्टिकल 226 है कॉन्स्टिट्यूशन का, आर्टिकल 226 इज ओनली मेंटेनेबल फॉर द गवर्नमेंट एड कॉलेजेस. तो प्राइवेट कॉलेज अगर है उसके लिए आर्टिकल 226 मेंटेनेबल नहीं है ना. ठीक, थैंक यू सर. और कुछ इसके आ जाओ. इसके अलावा भी किसी को कुछ पूछना हो तो
अरे अपनी जगह से पूछ सकते हो यार.
आवाज नहीं आएगी उनकी.
ऐसा?
हाँ एक माइक मार दो आप पीछे. नाम भी बताना अपना सब लोग.
हाँ जी.
ईयर कौन सा है?
यस.
Greetings, Your Lordship. My name is Judge Srivastav and I am currently pursuing BLLB from I am from Pakistan. Your Lordship, we have argued before various judges, and when I was arguing from appellant side in quarter final rounds, their learned judges said that Telegraph Act and Telecommunication Act will be applicable in the current case, and I did not read that particular act, and I have referred to IT Act, and he was quite satisfied with that. Then at night I did read that particular act, Telecommunication Act, and today in morning again in front of the learned judges, when I was from respondent side, I got some points from the Telecommunication Act, so I have just used that in my oral arguments. Then judges said that why you are using Telegraph Act and IT Act, that power is conferred from central government to the authorities, and I just said that authorities here may be referred to any person, and any person may be referred to the authority sitting as a college grievance redressal committee. So they have power to authorize the use of social media or anything inside the college campus. But they said that my arguments are vague. So again, the Lordship has said that use of IT Act should be there in this particular case. But I thought that no one has used that act. So Your Lordship, whether it is to be used or not, I just got confused.
It depends on the bench. It depends on the bench.
But Your
Everyone
Lordship,
comes from a different mindset.
रिलीफ चाहिए काम.
So, we are all scapegoats of such incidents. Vishal sir might get a relief from the same judge, and Nitin sir might not.
sir, that has happened with me today. I felt that.
No, you prepare well. See, you need to understand law will be same for everyone.
Indeed, Your Lordship.
Okay, so prepare very exhaustive research. So if you are prepared, you are confident that this is applicable, then you should be confident. Right?
I was confident, but then he said, you cannot apply this, but law is applicable in each and every case in front of each and every bench. Now, how I could convince that particular judge?
Then read again.
My apologies, my lordship, but I think the law is applicable as it is inculcated and so and so and so and so. That's how you see. You don't have to be argumentative. You just have to be persuasive in front of a bench. आपको उन्हें convince करना है.
Indeed, Your Lordship. Thank you so much. Much obliged.
Yes.
Thank you so
There's
much.
no need for such frivolities now.
आप आ जाओ आप sir. Right, sir.
Thank you so much, sir, for all the discussion of honorable judges.
Sir, it happens sometimes that we read a particular law or a law, but we don't know how to apply it in real life or how to connect it in real life. Like we know the substantial law, but we don't able to connect it to the present situation.
So that's okay.
or to understand the actual application of the law with the given condition or with the means during this preparation I understood that even though we know the actual meaning of the law, we are not being able to find the intention or the application of the law in a particular case, and not being able to explain the contention to the front parties or to explain the expression particularly related to that particular law. So how do we get this reasonableness to interpret law and to understand the crux of the law?
I think
How to develop that
Nitin
ability?
sir should explain this. See, whenever you're see all the laws, you have to apply them on case to case basis, isn't it? So first you have to understand the facts. After going through the facts, then you have to look at the statutes. What does the statute says? If you can't configure what the statute says and what is applicable, what is not applicable, what is relevant, what is not relevant, you which year are you starting?
I mean, third semester of LLB.
Third semester. So like, do you have the subject of interpretation of statutes?
Not yet.
So you are going to get a subject where you'll learn how to interpret the statutes. Like what should be the correct interpretation, and there you'll learn how a statute is applicable in different manners in different cases. On like, see, it depends on the case, it depends on the facts, and that's how you learn how to apply it. So you are a bit young, so maybe you'll get that learning next year, I guess. Yeah.
So इसमें तो मैं इसी को रेट करना चाहता हूँ.
Sir, please.
जब भी आप कोई सा लॉ मतलब की पढ़ते हो तो इसका जो रहता है जजमेंट रहता है लेफ्ट. तो एक्चुअली क्या होता है जो पूरा मतलब की रीड करते हैं तो उसको लॉ को पूरा लेके इंटरप्रेट करते हैं. जो भी उसके जो होते हैं फैक्ट्स होते हैं. एक्चुअली जब आप मतलब की डेली आप अगर एक करते हो रीड तो आपको लॉ और फैक्ट्स में मतलब की पूरा पता चल जाता है. अगर जैसे आपके पास दो केस है उसको लेकर हमने एक आर्टिकल केस तो आपको वहां से पूरा मतलब की जो फैक्ट को लॉ दोनों उसमें लिखी उसने भी आपके लिए आते हैं द हाई कोर्ट के भी आते हैं सेट से अगर आप डेली अगर करेंगे तो आपको लॉ और उसका इंटरप्रिटेशन उसकी एप्लीकेशन आपको पता चलेगा.
थैंक यू सर.
ये आपका जो क्वेश्चन है ना, सब थोड़ा कुछ बोल रहे हैं इसमें. जो कुलदीप सर ने बताया, चाणक्य ने बताया, बिल्कुल सही बात बताई. मेरे दादाजी कहा करते थे कि एक अच्छा जजमेंट सुप्रीम कोर्ट का या हाई कोर्ट का आपको उस एक्ट, उस कानून के बारे में पूरी जानकारी देता है. तो अगर आप किसी भी एक्ट पे, किसी भी पॉइंट पे कोई जजमेंट अगर आप निकाल के पढ़ते हो, अच्छा जजमेंट, कोई जजमेंट बहुत ऊपरी तौर पे रहते हैं लेकिन जो अच्छे डिटेल जजमेंट है वो अगर आप पूरा पढ़ लेते हो, मेरे ख्याल से आपको दोबारा फिर उस एक्ट के ऊपर, उस कानून के ऊपर कुछ और पढ़ने की आवश्यकता नहीं. उसमें उसका सारा प्रोसीजर दिया होता है, सारा इंटरप्रिटेशन दिया होता है और सब कुछ कंक्लूजन उसमें दिया होता है.
सर,
नंबर 1
नितिन सर ने पूछा भी था कि के.एस. मुत्ता स्वामी कितने लोगों ने पढ़ा. So it's a 300 पेज जजमेंट.
ठीक है, तो
isn't it?
सबसे पहले तो हमको जजमेंट पढ़ना चाहिए, तो हमको ये सब बातें क्लियर हो जाएंगी. दूसरा, एक कहावत है कानून की कि सिखाया पूत कचेरी नहीं चढ़ता है. किन ने सुनी? हाथ खड़े करो. किसी ने भी नहीं सुना. बहुत अच्छी बात. इसका मतलब ये होता है कि सिखाया पूत मतलब किसी बच्चे को आप सिखा दो कि बेटा ऐसा ऐसा कर लेना, और वो कचेरी नहीं चढ़ता मतलब कोर्ट में जाके वो ऐसा ऐसा कर ले, ऐसा होता नहीं है. प्रैक्टिकल चीजें प्रैक्टिकल करके आती है कई बार. तो कई बार हमको लगता है कि हमने ये कानून पढ़ लिया और हम उसको पूरा समझ गए, लेकिन जब कोर्ट में जाते हैं तो सब कुछ अलग होता है. यार इसमें तो ये लिखा है, यहाँ तो ये हो रहा है. ऐसा होता है हमारे साथ कई बार, ऐसा हमने अनुभव किया अपने लीगल करियर में. तो कुछ चीजें प्रैक्टिकल करके आती है, कुछ चीजें करते करते आती है. एक सेंस ऑफ लॉ बोलते हैं, सेंस ऑफ लॉ डेवलप होता है, वो आते आते ही आता है. आपको एक फाइल को पढ़ के आपको ये सेंस हो जाए कि इसका भविष्य क्या है, इसका जजमेंट क्या है. एट द एंड ऑफ द डे जब हम इस पूरे केस की कंक्लूजन में पहुंचेंगे तो आखिर में होगा क्या, ये होता है सेंस ऑफ लॉ. ये धीरे धीरे डेवलप होता है आते आते आते. जब आप काम करेंगे लीगल फील्ड में तो आपको धीरे धीरे बहुत सारी चीजें अनुभव में.
Thank you, sir.
I'd like to add one more thing. When I was a student of law, I had the very same question. When I was studying first year, second year, तो यही सेम क्वेश्चन मेरे दिमाग में भी चलता था. Because law books are the most boring books on the face of this earth. सबसे बोरिंग बुक्स अगर बनी है तो वो लॉ की किताब है. तो मुझे पढ़ना बिल्कुल नहीं पसंद था. तो वो मतलब आप जब करते जाते हो, आपके सामने प्रैक्टिकल केसेस होते हैं, when you learn to deal with the situations, then I think you'll get the grasp.
Thank you so much, sir, for your esteemed presence in the final rounds of 5th Internal Banking Law in 2025 by Moot Court Committee GNLC Indore. Sir, we are grateful towards your esteemed presence along with your insightful remarks on the questions put forward before the honorable benches. सर, हम सभी नए हैं और उनके बीच में डिकेड्स का एक्सपीरियंस आपके पास है और हमारे बीच में जब आप जैसे पर्सनालिटीज आती तो you becomes a role model for us. We have to pursue the our legal journey in the same way which you have done. So sir, एक बार मैं चाहूंगा कि हमारे फाइनल राउंड के जजेस के लिए बहुत जोरदार ताली. Thank you so much for your responsibility. Now I would like to invite Honorable Principal Sir of our institution, Professor Vipin Mishra, on the stage to felicitate the judges of our final rounds. Sir, please. I would request Faculty Coordinator of General Administrative Body of MCC GNLC, Kante Sharma sir, on the stage to felicitate our judges. I would like to request respected नितिन भाटी सर कि आपकी प्रेजेंस ने इस इवेंट को, इस कंपटीशन को जो लीगल एज होती है वो लीगल एज दी. मैं प्रिंसिपल सर से रिक्वेस्ट करूंगा कि हमारे जितने आज जजेस हमारे बीच उपस्थित हैं उनको एक मोमेंटो देकर इस पूरे इवेंट का एक स्मृति चिन्ह जो हम हमारे जजेस के प्रति अपने कृतज्ञता का एक चिन्ह प्रस्तुत करने जा रहे हैं. तो मैं रिक्वेस्ट करूंगा सर से कि हमारे बीच आज के जज के रूप में नितिन सिंह भाटी सर, एडवोकेट नितिन सिंह भाटी सर हैं, तो उन्हें स्मृति चिन्ह देकर उनकी एस्टीम्ड प्रेजेंस को एक्नॉलेज करें एंड प्लीज शो एज अ टोकन ऑफ ग्रेटिट्यूड फ्रॉम द एंटायर इंस्टीट्यूशन. प्लीज तालियां बजनी चाहिए. आपने बिल्कुल ये राउंड एंजॉय करा.
थैंक यू सर.
मैं प्रिंसिपल सर से, विक्रम सर से, कांते सर से रिक्वेस्ट करूंगा कि हमारे बीच आज हमारे फाइनल्स के जज के रूप में कुलदीप पाठक सर उपस्थित हैं, तो उनको स्मृति चिन्ह भेंट कर अपना ग्रेटफुलनेस हमारे कॉलेज की तरफ से शो करें. सर we were blessed with the esteemed presence of a learned advocate Shri विशाल सनोटिया सर. मैं रिक्वेस्ट करूंगा प्रिंसिपल सर से, कांते सर से, विक्रम सर से कि वह आए और सर को स्मृति चिन्ह भेंट करें. मैं आज हमारे गेस्ट के, आज हमारे इस फाइनल राउंड्स के जज के रूप में एडवोकेट श्री चाणक्य दीक्षित जी, और मैं रिक्वेस्ट करूंगा कि सुनीता मैम और हिमांशी सोनी मैम प्लीज मंच पर आए और हमारे फाइनल राउंड्स के जज का फेलिसिटेशन. I would request Badoria sir as well to please come on this stage.
आइए
ये फोटो सबके साथ में भी ले सकते हैं।
हाँ जी हाँ जी
ये ज्यादा बेटर है।
आइए
प्लीज आप तो आ जाओ, सब साथ में आ जाओ।
हाँ अच्छा
हाँ
ठीक
हाँ जी
नहीं
आगे
थैंक यू
Thank you so much, sir. जब लोग कोर्ट में जब सुनते हैं आपको आर्ग्यूमेंट करते हुए, जजेस बड़े ध्यान से सुनते हैं कि अब न जाने कौन सी नई चीज इस पर्टिकुलर पॉइंट पर आ सकती है, ऑन द गिवन सेट्स ऑफ फैक्ट पे कौन सी लीगल प्रीमाइसेस का क्या इंटरप्रिटेशन हो सकता है, सर से सीखने को मिलता है. वी आर सर really blessed with your esteemed presence. Thank you so much, sir, for accepting our invitation to such short. Thank you so much. Thanks to the team. Since we are done with the final rounds of internal ranking round 5th edition 2025, I would request all the teams, we are going to have a short ID break. After that, there will be a valedictory session. So all the participants are requested to be mandatorily present, and all the volunteers who have been assigned the task, please move towards your respective tasks. Thank you.
मेमोरियल सारे ले लो.
अरे यार क्या वहाँ करते भी जाओ
Score sheets break.
स्कोर शीट गई. हाँ गई. एक और चाय वाय के कपड़े वैलिडिटी इसको सब कुछ वैलिडिटी के लिए रेडी करना है. बजट वगैरह सब कुछ होगा. ठीक है क्या फिक्स भी आप नहीं
चाय खाओ चाय पियो बिस्किट खाओ दीदी पानी वाला खुली नहीं को पानी पिलाओ ये बंद हो गया ना कैमरा अरे सब इधर घुमाए पास हेलो हेलो इधर घुमाओ ना सब थोड़ा पीछे जाओ थोड़ा सा पीछे जाओ थोड़ा सा और जाओ बस ठीक है 4 लोग हैं 5 लोग एक पे कट गया नीला कट गई तू इधर आ जा इधर आ जा हाँ इधर आ जा अब वो कट गई थोड़ा सा तो पीछे जाओ अब सब आ गए अब नीचे जा बस आ गए तुम आ गए चालू है चलो भाई आज रहेगा कल का
कुछ भी जुलूम बोलता चला जाता है और फ्रीडम ऑफ स्पीच में जो है सारे बेनिफिट्स ले रहा। क्या आप लोगों ने कभी सोचा कि इसका बेंचमार्क क्या होना चाहिए? हर एक चीज का कोई ना कोई तो बेंचमार्क जरूर। बियॉन्ड दैट शुड बी स्टॉप। मैं जहां इशारा कर रहा हूं शायद आप लोग समझ रहे होंगे। दूसरा, मैंने बहुत डिस्कस किया, पॉलिटिकल साइंस के लोगों से भी डिस्कस किया, और गलती से मैंने 1993 में एक लेटर टू एडिटर नई दुनिया में लिख दिया और वो छप भी गई। तब मेरी नौकरी की शुरुआत थी। बहुत सारे लोगों ने मुझे फोन किए, दीजिए सर ये क्या लिख रहे हो आप सरकारी नौकर हो। मैं बता देता हूं क्यों लिखा। आर्टिकल 356 हाँ, चूंकि सब आप लॉ के स्टूडेंट हो, सबको मालूम होगा कि किसी स्टेट में जब कॉन्स्टिट्यूशनल क्राइसिस होती है, यानी संवैधानिक जो प्रक्रियाएं हैं जो फेल होती हैं, तब उस स्टेट में प्रेसिडेंट रूल लगाया जाता है, राष्ट्रपति शासन लगाया जाता है। और राष्ट्रपति शासन जब लगता है तब एक राज्यपाल यानी गवर्नर एक या दो उनके सहायकों के साथ पूरे प्रदेश को गवर्न करते हैं, कंट्रोल करते हैं, प्रशासन करते हैं। यही रूल है ना, यही है आर्टिकल 356, यही है ना। जब कॉन्स्टिट्यूशनल क्राइसिस किसी स्टेट में होता है तब एक राज्यपाल और दो उनके एक या दो सहायक, बड़ा प्रदेश है तो दो होते हैं, और अगर छोटा प्रदेश है तो एक होता है। वो अगर कंट्रोल कर सकते हैं तो अब तो 15% की कंडीशन हो गई। किसी जमाने में 94 मिनिस्टर्स विद वन चीफ मिनिस्टर थे। शायद आप लोग तब पैदा भी नहीं हुए होंगे, बहुत सारे लोग मालूम भी नहीं होगा। एक स्टेट में एक चीफ मिनिस्टर थे और 94 मिनिस्टर्स थे। तो मुझे समझ में नहीं आया कि अगर एक चीफ मिनिस्टर विद 94 मिनिस्टर्स उस प्रदेश की एडमिनिस्ट्रेशन को सही तरीके से नहीं चला पा रहे हैं, तो 356 के लागू होने के बाद एक राज्यपाल दो या एक सहायकों के साथ में उस प्रदेश को कैसे चलाते हैं? आप लोग विचार करिए, मेरा प्रश्न आपके सामने। कोई अभी जवाब देना चाहे तो मुझसे बाद में मिल लेना, यहां से नहीं चाहूंगा, क्योंकि आपको मौका मिले कि आप सीधे यहां से बात करें, तो डिस्कशन का पॉइंट होता है। पर मुझे अगर कोई बताना चाहता है तो स्वागत है। ऐसे कुछ पॉइंट्स जो हैं जिन पर आप लोगों को आगे भी मैं मौका दे रहा हूं आपको, अगर कभी मौका मिला तो कुछ और मेरे दिमाग में पॉइंट्स हैं, उन पर चर्चा करूंगा। आज चूंकि वैलिडिटी में जो है ज्यादा बोला नहीं जाता है, क्योंकि आप लोग जो विनर हैं वो प्राइज लेने के लिए उत्सुक रहते हैं, और जो विनर नहीं है, क्योंकि मैं नेगेटिव बहुत कम सोचता हूं, जो विनर नहीं, जो नहीं जीत पाए वो आगे और जीतने का प्रयास करें, क्योंकि कहीं ना कहीं आपकी जो तैयारी है उसमें कुछ न कुछ लैकनेस रही होगी, कुछ कमी रही होगी, जिसके कारण कि आप लोग नहीं। और फिर जब भी कभी कंपटीशन होता है तो विनर तो कोई, अगर एक सीट है तो एक ही विनर होगा। फिर वो ग्रेडेशन है, वो लूजर नहीं, वो ग्रेडेशन है कि नंबर 1 पर इस तैयारी इनकी थी इसलिए ये विनर है, उसके बाद नंबर 2 है, नंबर 3 है, नंबर 4 है। दैट इज जस्ट ग्रेडेशन। मैं उसको कभी विनर और लूजर नहीं कहता हूं। और अगर फेल की आपने डेफिनेशन का एब्रिविएशन कहीं डॉक्टर कलाम के शब्दों में सुना है, FAIL, दैट इज फर्स्ट अपीयरेंस इन लर्निंग। माने फेल वाले कभी जो है अपने को फेल ना माने कि आज हम पास नहीं होता है। वो आपका लर्निंग का इनिशियल फेज है। आप अपने एम को लीजिए और जो अपना बेस्ट हो सकता है वो दीजिए। पास फेल विनर लूजर चलता रहता है, इससे कोई फर्क नहीं पड़ता। सब यही है कि हमें हमारा बेस्ट देना चाहिए। मैं बताता हूं, जब मैं 12th करने के बाद बीएससी में गया तो जो हाईएस्ट परसेंटेज 12th वाला था वो 72% था। माय टारगेट वाज इन बीएससी फर्स्ट ईयर that 70% and I achieved that। पर आगे की बात सुनिए, जो 72 वाला था उसने 83। तो जो टीचर हम पे विश्वास करते थे बोले कि मैंने उनके पांव छूने के लिए झुका तो बोले नहीं, तुमने आपको मालूम ही नहीं आपके जो कंप्यूटर है उसके कितना परसेंट, मेरा टारगेट ही 70% था। तो बोले उसके 83%, तो फिर पाँच हुआ ही सर, अगली साल 83 वाले को बीट करूंगा। Can you imagine from this dice? I'm telling you कि अगली साल मैंने उस 83 वाले को बीट किया था, उसके 364 थे, मेरे 370 थे आउट ऑफ 450। तो आप टारगेट बनाइए, मेहनत करिए, दुनिया में ऐसा कुछ नहीं है जो आपके लायक आपकी कदमों में नहीं हो सकता है। दिक्कत सिर्फ ये है कि हम क्या चाहते हैं मालूम? शॉर्टकट। भगवान के पास भी जाते हैं तो उनसे कहते हैं ₹1.25 का प्रसाद चढ़ाएंगे, प्रभु अगर मुझे 70% बनवा देना। भगवान कभी 70% नहीं बनवाते हैं, मेहनत आपसे ही करा। आप जब मेहनत करोगे तभी भगवान आपको सपोर्ट करेंगे। और अगली एक बात जो सबसे फायदे की बात आपकी है, डोंट हैव एनी काइंड ऑफ एक्सपेक्टेशन फ्रॉम एनीवन, इवन फ्रॉम गॉड। यू डू योरसेल्फ, you give your best, you will find success, there is no doubt. So जो विनर है अपना पुरस्कार लें, और जो नहीं विनर हुए हैं अभी वो आगे की तैयारी करें। मेरी आपको सबको शुभकामनाएं हैं। आपने हमको बुलाया, मुझे लग रहा था कि जब मैं बोलना शुरू किया था तो लोगों में आपस में, तो मुझे लगा कि मुझे कुछ अलग तरीके से बोलना पड़ेगा, बिकॉज आई कैन अंडरस्टैंड योर थिंकिंग। ठीक है ना? यहाँ जो पहुंचा हूं वैसे ही सीधे उड़ के नहीं पहुंचा हूं। आई हैव सीन अ लॉट, बहुत छोटे से उठ करके यहाँ तक है। तो मैं आप लोगों से एक ही अपेक्षा रखता हूँ कि आप लोग अपना जो बेस्ट है वो दे करके आगे बढ़ेंगे। और मेरी सभी को शुभकामनाएं कि आप लोग अच्छे लॉयर, जज, क्योंकि आजकल हाई कोर्ट और सुप्रीम कोर्ट में तो जजेस भी बनते हैं, सब लॉयर से ही बनते हैं। और मैंने कोर्ट भी देखा है, हाई कोर्ट तो जाना ही पड़ता रहता है हमको इन जनरल। तो पुनः एक बार सबको शुभकामनाएं और अच्छा करें। जय हिंद, जय भारत। थैंक यू।
Thank you so much, sir, for your insightful words, which has motivated us to do best in our respective fields, whether it is the art of advocacy or it is just. Thank you, sir. Now I would like to invite Soni sir to kindly address the group. Have a big round of applause.
भारत माता की जय, भारत माता की जय। ज्ञान की देवी वीणा पाणी मां सरस्वती, युवाओं के प्रेरणा स्रोत स्वामी विवेकानंद जी एवं मंच पर उपस्थित सभी अतिथि। जैसे मैं जब मूट कोर्ट चल रहा था, जब आपकी प्रतियोगिता चल रही थी तब भी आया था, और मैंने उस समय भी आप जो प्रतियोगिता चल रही थी उसमें जो बातें हो रही थी वो सुनी। वैसे मुझे बताया गया है कि आज ही सेमीफाइनल पे था और फाइनल पे आज, उससे पहले कल अलग अलग राउंड में पूरी प्रतियोगिता चली। तो आप सुबह से ही सुन रहे हैं तो मैं ज्यादा नहीं बोलूंगा। और विधि के छात्रों के, विधि के विद्यार्थियों के सामने बोलना तो वैसे ही बड़ा मुश्किल बात है, क्योंकि आपका काम तो लगातार पूछते रहना, शब्दों को पकड़ना और उनको ठीक करके आगे बढ़ाना चाहिए। जैसे मूट कोर्ट में बोलने के लिए मेरा पहला अवसर, जैसे संगठन के विषय में, समाज के विषय में तो हम अभिनंदन बोलते रहते हैं, लंबा बोलते हैं। समाज में विद्यार्थियों में अखिल भारतीय विद्यार्थी परिषद का कार्य है कि विद्यार्थियों के बीच में जाना, विद्यार्थियों के विषय को एड्रेस करना, और राष्ट्रहित की बात करना, विद्यार्थियों को राष्ट्रहित के लिए लगाना। आज मूट कोर्ट है तो जो मैंने समझा, बताया गया कि ये मूट कोर्ट प्रतियोगिता है, लेकिन मैं आगे बैठा तो मुझे समझ रहा है कि ये मूट कोर्ट एक प्रतियोगिता नहीं है, एक प्रयोगशाला है। विधि के विद्यार्थियों को आगे बढ़ाने की एक प्रयोगशाला है, जिसमें विधि के विद्यार्थी यहाँ तर्क वितर्क करना सीखते हैं, और सबसे महत्वपूर्ण है सत्य के साथ खड़ा रहना सीखते हैं।
कि सच्चाई के साथ कितनी मजबूती से हम खड़े हैं, कितनी मजबूती से हम बात कर रहे हैं। क्योंकि जब फाइनल राउंड चल रहा था तो दोनों पक्षों में अपनी बातों को लेकर एक अलग प्रकार का डेडिकेशन था और अपने शब्द जो बोलने के समय जो शब्दों में तीखापन था, यानी कानून व्यवस्था में विधि की विद्यार्थियों में सबसे बड़ा अस्त्र जो बोलते हैं शब्द ही होता है। हमारे पास सबसे बड़े शब्द यानी अस्त्र के रूप में, शस्त्र के रूप में शब्द ही। तो विधि के विद्यार्थी उन शब्दों का कितने अच्छे तरीके से प्रयोग करके और इस न्याय व्यवस्था को नई दिशा दे सकते हैं। दूसरा ये कि जब मैं सुन रहा था तो एक बात हो रहा है कि हम अनुच्छेद धाराओं का तो बात करते ही उनके बारे में बताते हैं, उनका फिर देते हैं, लेकिन एक विधि के विद्यार्थियों में अनुच्छेद और धाराओं से भी ज्यादा महत्वपूर्ण है कि भावनाएं होती हैं। समाज के प्रति संवेदनाएं हमारे हृदय में होती है, तभी हम सही न्याय की ओर बढ़ सकते हैं। संवेदनाएं जब हम न्याय के लिए बात करते हैं, न्याय की बात करते हैं, क्योंकि अभी जब समाज न्याय की ओर अपेक्षा भरी दृष्टि से देख रहा है, अभी जो देश का वातावरण है न्याय की तरफ आप देख रहे होंगे, कई लोग लाल लाइन लेके संविधान बता रहे हैं, तो वैसे तो आज देश एक प्रकार से न्याय की तरफ देख रहा है और कई प्रकार से न्याय को भ्रम में डालने का प्रयास कर रहे हैं। न्याय से कई प्रकार की भ्रामक चीजें जो हमारे समाज में फैलाई जा रही है, तो उसका उत्तर भी विधि का छात्र दे सकता है। उस प्रकार से आज का जो आयोजन हुआ बहुत ही सार्थक हुआ। सेमीफाइनल में नहीं, फाइनल में था, लेकिन बाद में जब बाद में ऑफिस में बैठे हुए थे और किस प्रकार से आपने कितनी टीम 14 टीम लगाकर और अलग अलग क्लासरूम में छोटी छोटी कल क्लासरूम में सबकी डिबेट हुई, एक प्रकार से सार्थक आयोजन। और इसमें मैं आयोजक को धन्यवाद देना चाहता हूँ, कॉलेज की तरफ से जो आयोजन किया गया, इसमें लंबे समय बाद हुआ है। एक आपकी भी जानकारी में होगा कि लंबे समय से मूट कोर्ट कॉलेज में नहीं हुआ, कुछ जिम्मेदार लोगों ने जिम्मेदारी उठाई और लंबे समय बाद आपको मंच देने के लिए प्रयास किया और एक प्रकार से सफल सार्थक आयोजन रहा, क्योंकि इसमें जो हम देखेंगे कि विद्यार्थियों को एक मंच मिला है जहां वो अपनी बात कर सकते हैं, अपनी प्रतिभा में और विस्तार कर सकते हैं। तो वो मंच देने के लिए मैं सभी का धन्यवाद देता हूँ। कॉलेज में जो भी इस आयोजन में लगे हुए हमारे सीनियर हैं, जो आपके सीनियर हैं, उनका भी धन्यवाद देता हूँ। और यही अपेक्षा है कि जो भविष्य में न्याय व्यवस्था संभालने वाले लोग आज यहाँ बैठे हुए, तो आपसे यही अपेक्षा है कि भविष्य में न्याय के प्रति लोगों की आस्था बढ़े, उस दिशा में आपको काम करें। धन्यवाद।
थैंक यू सर। आपके वर्ड्स सभी युवाओं के लिए हमेशा प्रेरणादायक है। हमारा फेलिसिटेशन सेरेमनी में हमारे बीच आज के जो मुख्य अतिथि उपस्थित हैं, श्री दीक्षित सर, उन्हें एज ए टोकन ऑफ ग्रेटिट्यूड फ्रॉम आवर इंस्टीट्यूशन for his esteemed presence, which has marked the event a memorable one. I would like to invite Principal Sir and all other dignitaries seated on the stage kindly share the token of gratitude, a moment to the Honorable Sir. Please. एक बार जोरदार तालियां हों। अपने व्यस्त समय से हम सभी के बीच में उपस्थित होना I would request Principal Sir and all other dignitaries to present the token of gratitude towards P.O. Soni Sir. चीज जब हमने कमेटी में काम किया, ये जो काम कंपटीशन का था सर, इसमें कम से कम 1.5 साल का समय लगता है। 1.5 साल के समय कम से कम लगता है इस ऑर्गेनाइजेशन को पूरी खड़ी करने में और इसको पूरी व्यवस्थित रूप से संचालित करने, और हमें मात्र 1.5 महीना हुआ है। और इस कॉलेज की फैकल्टीज की मदद से, हमारे बच्चों के डेडिकेशन की वजह से इतना सफल आयोजन हो पाया। सर मुझे एक बहुत मार्मिक चीज याद आती है जिससे मेरा मन रो पड़ा जब मैंने एक बच्चे को देखा, उसकी मेहनत को देखा। मेरी बहुत फेवरेट कवित्री इंदौर की मिट्टी से जन्मी महादेवी वर्मा, उनका एक बहुत सुंदर लेख आज से करीब मैंने 14-15 साल पहले पढ़ा हुआ, जब मैं तीसरी या चौथी कक्षा में। वो लिखते हैं राजेंद्र बाबू। राजेंद्र बाबू वही है जो भारत के राष्ट्रपति थे। वो राजेंद्र बाबू के घर जाते हैं और भेंट में देते हैं इलाहाबाद का सुप्रसिद्ध कपड़ा जिससे आप ध्यान चाहते हैं। और वहां जाके क्या देखते हैं कि राजेंद्र बाबू में, राजेंद्र बाबू के एक पांव में एक मोजा अलग है, दूसरे पांव में दूसरा मोजा अलग है, और उस समय में वो भारत के राष्ट्रपति। मैंने इस कॉलेज में हमारी कमेटी के बच्चों को देखा है जो 2 बजे रात को इस कॉलेज से गए, सुबह 4 बजे वापस इस कॉलेज में आ गए और 1 महीने में 150 से ज्यादा मीटिंग होने के बाद इस आयोजन को सफल करवा पाए। उस समय अगर हम कहें कि उनकी दाढ़ी नहीं बनी है, तुम्हारे मोजे कहाँ जा रहे हैं, तो हमारा जो आकलन थोड़ा सा टूटा हो। इसीलिए सबसे पहले जो विनर्स हैं उनका पार्टिसिपेशन है, उन्होंने तो बहुत कुछ किया, पर हमारे जो बच्चे थे जिन्होंने दिन रात एक करा और निस्वार्थ भाव से, क्योंकि 4 मेंबर में भी हो जाएंगे तो 4 लोगों से ज्यादा शेयर नहीं हो सकता, तो निस्वार्थ भाव से बिना कुर्सी की लालच से, अगर किसी ने, जो कृष्ण भगवान ने कहा योगा कर्मशु कौशला, बच्चों का सजेशन था सर पीयूष जी, हमारे यहाँ पर 4 दिशाओं में 4 महावाक्य लगे हुए हैं जो चारों वेद और 4 भावनाओं के प्रतीक, जैसे हम ब्रह्माष्टमी तत्वमसि। उसके अलावा हमने ध्येय वाक्य लगाए जो दशो उपनिषद, श्री रामचरितमानस, वाल्मीकि रामायण से आए, जिसमें मांडुक्य, मांडव्य, छांदोग्य उपनिषद है, ब्रह्मचारिण्यक है, और ऐसे कई हमारे शास्त्र जिनकी ऐसी वाचनाएं जिन्होंने बच्चों को सिखाया है कि आप सिर्फ कर्म करिए और इसको ईश्वर को समर्पित कर दीजिए। तो इस कॉलेज से सर हमने वो ऐसे बच्चे देखे हैं जो 20 साल की उम्र में तत्व चिंतन कर रहे हैं, और उन्हीं का ये प्रभाव कि ईश्वरीय आशीष प्राप्त हुआ, जिस काम को 1.5 साल में भी कर पाना मुश्किल था, 1.5 महीने में वो बच्चों ने कर दिया। और इन बच्चों ने मुझे मेरे बाल मिलने के, वो राजेंद्र बाबू जो भारत के राष्ट्रपति पद पर बैठने के बाद फटा मोजा पहनते हैं, तो मैं उन्हें सिविक सेंस गलत नहीं कहूंगा, उन्हें अपनी कर्मठ निष्ठा कहूंगा जो हमारे बच्चों ने यहाँ दिखाई। तो सर इसमें बड़ा योगदान था हमारी जीएबी का, ये जनरल एडमिनिस्ट्रेटिव बॉडी होती है, तो सर हमारी जीएबी में हिमांशी सोनी मैम थी, उनके सपोर्ट के बिना ये कर पाना बिल्कुल मुश्किल था। हमारे चेयरमैन विपिन मिश्रा सर, तो एज ए टोकन ऑफ ग्रेटिट्यूड हिमांशी मैम को देने के लिए मैं सभी मंचाती अतिथियों से अनुरोध करूंगा कि सर अब हम हमारी सर्टिफिकेट सेरेमनी स्टार्ट कर रहे हैं, तो आई वुड रिक्वेस्ट टीम टू प्रेजेंट टोकन ऑफ ग्रेटिट्यूड ऑन दिस स्टेज फॉर द हिमांशी। मैं रिक्वेस्ट करूंगा कांति शर्मा सर से कि वह आए। सर हमारे फैकल्टी कोऑर्डिनेटर हैं, और सर जो आपका उत्साह था वो बच्चों के लिए सच में निशब्द है, हम कुछ कह ही नहीं सकते। आई हैव नो वर्ड। I would request Vikram Shekhawat sir, please come on this stage. Please. मेरी कॉलेज की जर्नी में विक्रम सर और कुणाल दादा, आई हैव नो वर्ड्स कि मैं ग्रेटिट्यूड किसी भी तरह से शो कर पाऊं, चाहे डिबेटिंग हो, मीटिंग हो। मतलब डिबेट में हमें इतना परिपक्व कर दिया कि हम मुख में भी आए तो एक कुशल सेवक के रूप में अपनी सेवाएं दे सके। तो सर थैंक्स टू यू। आई वुड रिक्वेस्ट जीएबी मेंबर आदित्य सर, प्लीज कम। आदित्य सर का जो सपोर्ट था, वो सपोर्ट हम सभी के लिए, हम स्टूडेंट्स के लिए, तो हमारे रोल मॉडल आदित्य सर। उपलब्धियों के साथ सहजता आदित्य सर। सर अब हमारे पास कुछ वॉलेंटियर्स हैं जिनके सर्टिफिकेट है बहुत पास पास। हमारे बीच अनीता गहलोत मैम जिन्होंने हमारी मूट कोर्ट को हमेशा सपोर्ट दिया, तो प्लीज मैम एक्सेप्ट दिस टोकन ऑफ ग्रेटिट्यूड फ्रॉम आवर कमिटी। हमारे पास वो जो हमारे अतिथि जन के इतने व्यस्त समय, आज मुझे पता चला न्यूज सर के वो 1:30 बजे से फाइनल्स के राउंड सुन रहे हैं। It is very difficult to listen any person for a 5 minute if I speak more than 2 minutes. तो सर we are also grateful to us. अब मैं फटाफट सारे वॉलेंटियर्स के नाम लूंगा, वो सारे वॉलेंटियर्स मंच पर आएंगे और अपना सर्टिफिकेट लेकर जाएंगे। अंचल ओके, प्लीज कम ऑन दिस स्टेज। Maintain the queue fast. All the volunteers gather. अंचल सिंह परिहार, अंजलि विश्वकर्मा, अश्वी पंडित, चंचल कोटे, दीपा जायसवाल, दीक्षा सोनी, दिव्या तिवारी, हर्षिता वशिनेंद्र, हेमा मेवाड़ा, मानवी यादव, नेंसी पाल, नीरजा व्यास, निधि भातम, निशा परमार, पूनम दानिया, प्रगति जैन, प्रिंसी पटेल, राशि जैन, रितिका जाट, साधना नरवलिया, सेतुल चौहान, साक्षी राहुल, समीक्षा जैन, संतोषी प्रजापति, सौम्या पाटीदार। चार बच्चे आए चार बच्चे एक साथ नेक्स्ट 4 next 4 आ जाओ आओ बेटा चारों So participate for those please. चलो चार चार आओ चार चार जल्दी आओ थोड़ा जल्दी आओ
सबको आ जाओ बेटा
Team wise, all the participants.
Team wise, all the participants, please be on the stage. IIR 03, all the members. IIR 03, IIR 03. उसके बाद IIR 07. Please come on the stage fast. IIR 13, IIR 15. Please come on the stage fast. Team code 07, IIR 07, IIR 13, IIR 19, 15, 19, 20, 21, 26, 31, 21, 26, 31, 32, 34, 39, 40, 45, 46, 58, 61 and 63. The last team 63. सर बस 5 टीम next. Okay. winning teams के सर अब results में clear सर हमारी
Quarter finalist team IIR 11. Please come on this page fast. Quarter finalist team IIR 30. Tulika, Shaurya Pratap Singh Tomar, and Ayush Pawar. They qualified in the quarter final round. Out of 70 teams, they were in 8. IIR 05 quarter finalists Dini Raghuvanshi, Utkarsha Jain, Asna Jain. IIR 17 Vinit Gupta, Gauravi Goyal, Manas Parsai. Team code IIR 17. Quarter finalist. IIR 55 Tanya Soni, Soumya Base, Nidhi Shukla. Quarter finalist. Please come on this.
Next.
Quarter finalist. All semi-finalists. अब इन 70 टीम में से हमारे पास 4 टीम सेमीफाइनल्स में पहुंची थी। 70 टीम्स में से 4 टीमों में जाना अपने आप में टफ कंपटीशन आया यार। सर अब हम फाइनल राउंड्स पे जाएंगे। फाइनल राउंड्स पे सर को रिकॉग्नाइजेशन उसके लिए हमारे पास कुछ अवार्ड्स हैं जो फाइनल राउंड्स तक मिले। हमारे पास बेस्ट मेमोरियल अवार्ड है। हमारे पास 1 महीने में कॉन्स्टिट्यूशनल थीम पर 30 पेज के प्रिस्क्राइब फॉर्मेट में जो आवर ब्लू कोड या ब्लू बुक एडिशन होता है उसके साइटेशंस को मैच कर पाना और उनके कंप्लायंस में आप लोगों ने मेमोरियल बनाया। आप देखिए रिस्पोंडेंट और अपने साइड का क्या है। तो हमारे पास बेस्ट मेमोरियल अवार्ड है
गौरी जोशी।
प्लीज कम ऑन दिस
इनके बाद है बेस्ट मेमोरियल ईशा श्रीवास्तव।
प्लीज बी ऑन द स्टेज। आपकी ट्रॉफी आ
एंड शिवानी शर्मा।
सर टीम को बेस्ट मेमोरियल अवार्ड जीता है। एक बार जोरदार तालियां हो जाए। इतना शानदार मेमोरियल आप पढ़ें। वी विल शेयर द कॉपी ऑन द ऑफिशियल चैनल्स। इतनी शानदार ड्राफ्टिंग थी इन लोगों की कि हमारे लिए बड़ा मुश्किल था कि बेस्ट मेमोरियल कैसे शॉर्टलिस्ट करें। हमारे कुछ कमिटी मोहित चौहान,
पायल प्रधान, भूमि मिश्रा, वंश चौहान, आयुषी कमरे, साक्षी सोनी, मुस्कान मिश्रा, दर्शन कौशिक, राजू सिंह, नियति, विशिका जैन, ईशान श्रीवास्तव, मुदित शर्मा, ऋषभ कुमार पाटीदार, शिवम गुप्ता, केशव उपाध्याय, प्रांजल जोशी, रौनक प्रजापति।
Congratulations all of you.
सर कुछ अवार्ड्स हैं जो कमिटीज को जाने की मेहनत सबकी बहुत शानदार थी पर कुछ का एक्सेप्शनल वर्क था मोडेस्ट अचीवर अवार्ड गोस टू भूमि मिश्रा प्लीज कम ऑन दिस स्टेज रजिस्ट्रेशन में सर हमारे कम से कम 400 कॉल और ईमेल्स करें की टीम ने 400 मेल्स एक हफ्ते के टेन्योर में भूमि मिश्रा मोदी शर्मा पीक परफॉर्मर पार्टिसिपेशन के हेड थे इनकी वजह से 70 रजिस्ट्रेशन 210 पार्टिसिपेशन है 250 वॉलंटियर रजिस्ट्रेशन जिसमें से हमने 50 क्लिक कर मोदी शर्मा पीक परफॉर्मर टेक्निकल मेस्ट्रो राजू सिंह गणावा प्लीज कम ऑन द स्टेज सर 5 एंगल से हमारी लाइव प्रोसीडिंग चली रिसर्चर टेस्ट के लिए हमने सॉफ्टवेयर बनाया जिस सॉफ्टवेयर का कंप्लीटली कंप्यूटर बेस्ड टेस्ट था यूजर आईडी पासवर्ड थे इसके अलावा ग्राफिक डिजाइन करें तो हमारे टेक्निकल मेस्ट्रो राजू सिंह गणावा वंश चौहान वेतन ऑफ एक्सीलेंस अवार्ड गोज टू वंश चौहान हेड ट्रेनिंग एंड मेंटरशिप प्लीज कम ऑन दिस स्टेज 3 घंटे तक हमारे वर्कशॉप अटेंड करना 3 दिन तक 350 लोगों को एड्रेस करना 3 दिन तक हमारी वर्कशॉप हुई है उसमें हमारी वर्कशॉप देखी मेमोरियल ड्राफ्टिंग एक्सेट्रा इंसाइटफुल क्रिएटर दर्शन कौशिक प्लीज कम ऑन दिस स्टेज दर्शन कीन सीकर प्रांजल जोशी प्लीज कीन सीकर प्रांजल जोशी एक्सपायरिंग स्कॉलर सत्य प्रकाश प्लीज कम ऑन दिस स्टेज सर बहुत मेहनत करी सभी बच्चों ब्राइट लर्नर यानी सिसोदिया प्लीज कम ऑन दिस स्टेज निर्जा व्यास गोल्ड ऑरेटर प्लीज कम ऑन दिस स्टेज बहुत अच्छी क्वालिटी कोर्टरूम मास्टर की अगर फाइनल्स में निर्जा रही इंक्विजिटिव लर्नर नैन्सी पाल प्लीज कम ऑन दिस स्टेज बहुत कम समय में इतना कमिटी का काम करना नैन्सी बहुत अच्छा है जीएनएलसी की लेगेसी को आगे बढ़ाने वाले सारे स्टूडेंट्स हमारी कुछ टीम्स हैं जिनने थ्रू आउट द कंपटीशन हमने कुछ अवार्ड्स कलेक्ट करे और हमारे फाइनल्स के कुछ अवार्ड्स जो हमने बेस्ट रिसर्चर अवार्ड बेस्ट मेमोरियल अवार्ड बेस्ट स्पीकर अवार्ड और रनर अप फाइनल्स के ये हमारे अवार्ड्स हैं तो अब हम ये अवार्ड्स शुरू करते हैं तो इस पूरे कार्यक्रम की एक शान है सबसे पहले हमारी जनरल एडमिनिस्ट्रेटिव बॉडी के हमारे स्टूडेंट मेंबर्स जो अभी प्रैक्टिसिंग एडवोकेट हैं आई वुड लाइक टू इनवाइट आदित्य प्रताप सिंह सेंगर सर टू प्लीज announce the best memorial best researcher and I would request all the dignitaries on the stage to give this award. सम्मानित मंच प्रमुख सदस्य सबसे कठिन काम मुझे दिया है क्योंकि अगर मंच से बोलने वाला कोई ऐसा व्यक्ति होता है जिससे लोग नाराज होते तो वही है कि जो सेल्फ अनाउंस करता है इसलिए हमारा नाम अनाउंस किया है फिर भी जो मंच से दायित्व किया गया इसका तो करना रहेगा बेस्ट रिसर्चर अवार्ड गोस टू रुपेश परमार आई रिक्वेस्ट सुनीता सती मैडम प्लीज कम ऑन द स्टेज I also request Neeraj sir to please come on the stage and present the award. Next award, Best Speaker. The Best Speaker award goes to
Tulika Behnani for presenting the award. I request Pavan Badoria sir and Pankaj Bhattacharya sir, please come on the stage and present the award. Next award is runner-up. Runner-up team award goes to IRR 04, team of Uttar Slim, Anurag Sudhare, and Jayavardhan Tiwari. For this award, I request Virendra Bhagat sir to please come on the stage and present the award. And the winner of IRR 5th edition is team code IRR 06. Team I request members of the team, Sonika Upadhyay, Avika Sharma, and Mukesh Parmar to please come to the stage, and I request Ashish Rao to please present the award on the stage. I request Kunal sir to please come to the stage. And I request Anita Gehlot ma'am and Panchi Soni ma'am to please come on the stage and present the award to the winner of IRR 09. For a photo, I request all the members to please come on the stage quickly because we are already running short of time. All participants, please remain in the auditorium. We will have a group photo afterwards. दोनों ऐसे प्रॉब्लम once again congratulate all the